Seen it, what is there in the,
Matter has not reaching
Huh?
for the 10 to 10, 11 times has been matter has been came to.
then what you should do, you should mention it 130. You should mention it 130. You should look at the cause title.
List number 1
Cause
for
list,
orders.
it's mentioned, it's 130. Call the list.
Number 1 for orders matter serial number 1 E. Ravi Shankar.
Use the mic.
And for the petition, my lord. We are withdrawing the writ petition, my lord. Impugned order is passed on the order.
Memo is well stating that the dispute between the parties is amicably settled, and therefore the petition wants to withdraw. Memo is not taken on record and dismissed as withdrawn. Yes, next.
Serial number 2 preliminary hearing Vinay Swami C.
My lord, yesterday the matter was posted.
Huh.
The judge is indisposed.
Huh?
Judge is indisposed. I'm told hospitalized. I am not
Oh.
sure. I moved the in-charge judge. My lord, the plaintiff deliberately, already they had come prepared, files an NOC wakalat and takes time. Now the matter is posted on 17/8. My lord, the thing is, 2 essays have been dismissed.
So 17/8 is one
Sorry.
day.
It is now posted to, just tell your lordship. Next month, my lord, if I'm right, it has gone to the next month because the judge is disposed. The in charge just says, I am not here the matter. And five nine, date is 5/9.
What is this IA?
My lord, I am just seeking for direction to consider my application.
No, no, what is that IA I said?
39(1) and 2, my lord. They have got an injunction order.
Please come. Presented petition is facing the following prayer. Land council the petition submits that an application under Order 39 Rule 1 and 2 is filed on 1/12/2025. And the court has kept the same pending without passing any orders. Right from the, without passing any orders from the last more than 8 months. Considering the submission that will counsel the petitioner, the so-and-so is directed to consider so-and-so.
My lord,
Within a period of 2 weeks from the date of receipt of the copy of the order, petition is at liberty to advance the matter.
my lord, Court Hall 17 is the in charge judge of Court Hall 16.
Whoever it is will do. Yes.
Secretary Omkara KB for petitioner.
Yes.
Petitioner, my lord, in this case. This is the small synopsis, my lord, pertaining to the case.
Yes.
May I, my lord? My lord, the matter pertains to alias Santana law, my lord. The parties to the suit are
I think we'll understand it some other day. The list is 150 now. This law itself is what you're referring is something new to me, which I have to
it
understand now.
took 3 months, my lord.
Huh?
I took 3 months to understand.
That's why it might take for me, it may take some more time. We'll hear some other
My
day.
lord, one submission, my lord. As far as this case is concerned, now it's a suit for partition. My lord, in the suit for,
The rejection of plaint basing on some,
yes, and it is my submission, my lord. Alias Santana law is not all that great to understand. Give me 5 minutes. Give me 5 minutes or less than 5 minutes.
2:30.
Because
2:30.
yes, court
No,
may-
I'll hear it at 2:30.
Yes, court may kindly remember, recollect, on 12/8 it was posted. On that day, I brought to the notice of the court that entire suit is stayed, further proceedings. Therefore, it was ordered to be called today at the top of the list.
Correct, but this.
And alias Santana law may not be.
2:30.
Yes,
Here.
yes,
Next matter.
I shall explain.
Yes.
ಇದು ಕೊಟ್ಟಿದ್ದು ನನಗೆ ಕಾಪಿ ಕೊಡಿ.
Yes.
The petitioner,
For respondent.
the respondent filed the application,
Mm.
section 92 of the CPC
Mm.
for sue the suit against the respondents under section 92 of the CPC.
Mm.
That was allowed and passed an order. Lord, that is annexer is page number, that is
So leave is granted.
leave is granted. That is
Mm.
in the order sheet, my lord.
At page 73, type to copy.
Yes, my lord. That is the para number 14.
Mm.
The last time it is, I have read the,
Please read.
that is order, least it, the petition, my lord. That is the petition. I have produced the 148. Is the itself is not maintainable, the
No.
least deed.
We'll go step by step. Please come to para 14, read the finding. Then you can come to, you can take the court to the plaint and other things.
Para 14, my lord. Para 14 of the order, my lord. It is the, yesterday I have read the para number 14.
I don't remember what you read yesterday.
Yes, once again I read, that is para number 14, my lord. That is para number 14 of the order, my lord. Internet page number 24, para number 14, my lord. In this case, the allegation of the petitioner is that the respondent trust and amended the trust deed and removed the petitioners from the membership illegally. However, it is the contention of the respondent that they have removed legally. To strengthen their contention, they relied upon the letter dated 24/3/2025, which shows that complaint was signed by 180 members making allegation against the petitioner. Another document is dated 8/5/2025, which is the notice given to Ganesha Prakash Sridhar Govardhan Narayan Murthy by saying that their membership is going to be suspended as there is a misuse of their trust. Another document is the letter written to the chairman regarding amendment to the trust deed issued by the Ganesha dated 12/6/2025. Another notice was sent to the petitioners. The cancellation of lease deed is also produced. The proceedings of the committee amended trust deed and order passed in WP are also produced. In this case, on pursuit of the materials available on record, even though the respondents have produced the notice regarding intimation towards the termination of lease, but this aspect have to be decided before the court. There is mistake crept in that without disposing of the petitioner, the suit came to be registered. However, there is a direction by the Honorable High Court of Karnataka to dispose the application first, since there is a material to show that these trustees were initially in the trust and now the respondents have removed them from the trustship. Whether that removal is legal or not, whether the amendment is properly done or not at all, to be decided in the full-fledged trial. Hence, it is just necessary to given permission to sue as per the section 92 of CPC. Since it is public trust, the provisions of section 92 of the CPC is to be invoked. Hence, the petition is to be allowed. Accordingly, point number 1 is answered and affirmative. Point number 2, view of finding the point, this court proceed the pass following in view of the direction of the Honorable High Court, WP in 48/44 of 2026, to dispose of the miscellaneous petition. The miscellaneous petition 148 of 2000 filed under section 92 CPC is allowed. Leave is granted to the petitioner to institute the suit for the reliefs prayed in the plaint accompanying to the petition. Office is hereby directed to register the plaint accompanying to the petition as original suit by the member already allotted and put up. I have produced the, that is petition copy filed by the petitioner before the court. The 3 criteria that is mentioned in the section 92 of the CPC is not fulfilled.
Where is the petition filed? by
Petition,
them?
I have filed that is petition 148. That is the petition I have additional document. I have produced the copies. Page number 214. 214. Memorandum of miscellaneous petition under section 92 of the CPC 908. Additional document. Additional
Oh,
document.
it's not there.
Additional
The documents are till 212.
212, after 212, 214, I have filed. File ಮಾಡಿದ್ದು sir.
It's not there. According to him, there is some more papers after that. Look at the file if it is there. These are the only documents. It's not there.
My lord, I may be read, my lord. That is.
How will you read without me having the papers? Or you have to give me one more set of it.
212 ಲಾಸ್ಟ್ ಇದೆ ಪೇಜಿನೇಷನ್
Kindly pass on.
File ಮಾಡಿ. It is filed by him only. Advocate for the petition. 240 is the miscellaneous petition memorandum.
ಅದಿದ್ರೆ ಇಲ್ಲ ಇತ್ತು
Very careful. It is his paper to 3 5.
ಇದ್ರೆ ಕೊಡಿ
ಇಲ್ಲ, ಇಲ್ಲಿದೆ. 2 lines I will read, my lord, permitted.
Because
2 lines.
that petition itself is relevant. When you say that, it will not fall under section 92 of the CPC.
230, my lord, that's passed, my lord.
Already 231 matter is there, passed over. It will take lot of time. Tomorrow? Yes, next.
Tomorrow, my lord, top of the list. my lord.
Could I make a mention? No. I feel discomfort so far as my health is concerned. I'm suffering from leg pain. Despite I came today, but it lost its accommodate me on Monday or Tuesday.
Tuesday.
2:30 I may not wait. I have to
Tuesday,
go home.
Tuesday.
Tuesday.
Yes,
Tuesday next week, my lord.
Yes.
Yeah, tomorrow it may be taken, my lord. Tomorrow it may be
He has some
taken. Because
inconvenience.
day by day, my lord, the senior council is avoiding the this proceedings, my lord. That's why
So not like
I am
that,
ready.
but
Last
trial-
moment also, it is said, my lord, yeah,
But
according to him, my lord, it is my party's is mistake. I am agreed, my lord. But it is not to say it is next week, my lord. It's tomorrow it may be taken, my lord, anyhow.
Let me certify.
I read only,
My caliber is concerned. I don't
they
want
have
any
also, they,
adverse remarks. I can tell the law on the file. There are section 19.
No, don't go to that.
He makes section.
We'll take it up, we'll take it up on Tuesday. Yes,
He would have been regretted for making that submission.
Tuesday.
tomorrow it may be taken.
Tuesday. Yes, next.
He should be regretted to making such submission.
I am not regretted, my lord. I got,
Next.
Still number 5.
Why this letter of 14 July is put up now? This is dated 14 July 2026. Why is it put up today? Call the registrar.
Still number 6. Ganapati Bhatt, a petitioner.
Please. May I please? Yes. There are two writ petitions. Arising out of two orders passed by the trial court on IA number 16 and IA number 17.
What is IA number 16?
IA number 16, my lords, is the order sought under section 151 for police aid.
What is the
Two.
other one?
Other one, this police aid application 151 is filed by the plaintiff. Other application IA number 17 is filed by the defendant, that local inspection must be held before police aid is granted. If the facts are like this in a gist, my lords.
Your application is dismissed, their application is allowed.
Yes, exactly. The gist is like this.
Hmm.
Plaintiff approached the court for injunction against the defendants not to trouble him in putting up the fence for the plain shell property. Defendant appeared and defendant stated there is no such property at all. In fact, I have purchased 22 guntas which is in my possession. There is a school and therefore the identity is in dispute. They are not in possession of my property. If at all they have their own property, I have no objection. Which is the case. They say they have about 6 guntas of land. the description is something else. So defendant's cases, they are not at all in possession of that alleged plain soil
What
property.
happened? Injunction is granted.
Injunction, what trial court said is, injunction is allowed,
When
and
was-
matter went
when
up to
was-
the, please, my lord.
Injunction granted.
The date of injunction order, my lords, please. The order of injunction granted by the trial court is 1st October 2022,
Hmm.
page 41.
What happened thereafter?
This was challenged before this honorable court, my lords.
Hmm.
And may I beg to take my lords kindly to the order of this honorable court, page number 51, annexure D. Defendant challenge date, my lords. 19th July 24. May I beg to take my lord to page 52.
So what is the result?
Result is this honorable court said
Yes.
status quo should be maintained, para 7. During the course of arguments, both the parties fairly submit that in the interest of justice would be served if the parties are directed to maintain status quo under the property concerned, with the exception of respondent herein permitted to fence the property without disturbing the already existing structure on the property. This was the order. Status quo, but he can fence it, but don't disturb my property without existing structure, because my property is.
So how does this status quo fencing and all will?
This exactly. I am grateful. This exactly has created problem.
Why did you? Because you're the one who accepted that.
Now, I said, I should not, what the learned counsel said was, he is in possession of certain property, he can fence his property, but let him not enter in my property.
No, according to you, there is no property at all. in
No
your
property
case.
at all. Therefore, we say, he says there's some other property he is claiming. But what he wants to actually do is, he wants to come inside my property and fence. This was the order, my lords. This created some problem, my lord, with great respect. My lord. This was the order. The operative portion of the order is page 56. Operative portion of the order is maintain status quo, but respondent is permitted to fence the property concerned without tampering with already existing structures. This was the order passed to the honorable court. My lord. Then what he does is
Consent order.
consent. This based on this, my lord, what happens is, he now, after this page 56 I read, my lord, just now, page 56 is the order for my lord's kind consideration. Page, without tampering with the tamper with the already existing structure. Now, my lord, thereafter what he does is, now he wants to enter into my property, therefore he cannot simply enter because the school, there is a compound wall. Now he says, I want police aid. Based on this, he goes to trial court and I want police aid to fence the property. And that came up for consideration. Again, one more writ petition, page 58, we challenged when police aid was granted. Since the Honorable High Court said, I will grant the police aid. Then page 58, my lords. There also we said he can fence his property, should not enter my property. So Honorable High Court said, this Honorable Court said, my lords, page number 60, last line, my lords. Since the petition defendant did not object to the permission granted by the court or the trial court to put up a fence without touching or altering any other structure already put up, etc. Then
Yes.
the Honorable Court said there is no need for police aid if he can, para 61, page 61, please, my lord, at the top. Page 61.
It is made clear that the respondent number 1 plaintiff shall not press the application seeking police protection, since the defendants have not raised any objection for putting up a fence in terms of the directions issued by the court.
Yes, yes. But they should not enter my property. He can fence his property, because my lords, whether there is a property or not is left to him, but he should not enter my property, that's all.
Kind of misuse statement shouldn't have been made before the court.
No,
at one go,
with great
at
respect.
one go, you say that there is no property, and at the other go, you will tell the court that let him do whatever he wants.
No,
let
not
him
enter my property, my lords, because
No, where is his property? Where is your property?
my property is intact. There's a compound wall is
No,
intact.
it
We're
is
in
just a
possession of this
mockery
property.
of, it's a pure abuse of process, these kind of writ petitions and these kind of concessions before the court and
My
coming
lord,
again
my
back to
lord,
the court with this
may I
kind of.
submit, even now they say they have their own property is different than mine, my lords.
No, what should be the
It's
stand
left.
of the defendant? If that's your case, that there is no property, you should have said, there is no property existing, question of fencing the property does not arise. You say, let him fence the property, but not enter into my property. And your specific case that there is no property at all. And keep on one after the other writ petitions coming to the court on concession made by the court. Court keeps on disposing it. Is it not creating unnecessary chaos and confusion?
Therefore, may I beg to submit like this, my lords. Now, what happened was thereafterwards again he won for one more application. After this, he said he withdrawing the police aid application, my lords. Withdrew it. Then again, my lord comes up before the honorable court. The municipality did not allow me, etc. Then the honorable court says you take the law as proceed as per law. Again files one more application, 151. Now, what the trial court now does is in that 151 application, I filed at that moment, my lords. Please demarcate the properties. Allow me to demark my properties. Let the commission be appointed as far as my property is concerned. Let them demark it, or his property can also be demarked so that there is no confusion, my lords. And
No, I think for all the confusion this petition has created, we should let this injunction or this police protection order continue and dismiss the seconded petition.
Subsequently, what has happened also, I beg
So
to.
problem is you are adding to these problems.
No, my lords,
Had your stand been clear in the first writ petition, all this wouldn't have happened.
my lord, may I beg to make this clear, my lord. They consistently say they have their property. Then the honorable court's question would be to me, why are you interfering? Their property is different, your property is different. Then, my lord, we will be caught because honorable court's question is, if what objection we have if they have their own property?
No, because already you have filed a written statement, your stand should be the same.
Yes, same stand, my lord.
As per the question of the court, stand of the defendant shouldn't change.
I bow down, my lord, sometimes great respect, my lords, because when this question cannot be answered because they say their property is different. And we say our property is different, but we also say that there no such property. They say there is a property, there's different property, they say, my lords. Now, my lord, what happened is now subsequent application, my lord, directly take your lords up to kind page number 84, my lord, impugned order. Page 84.
Yes.
Now the trial court, my lords, one sentence before I read that, my lord, page 83 last, please, my lords, how it has come. Page 83 last, please, my lords. There is a condition that the fencing should not tamper.
No, we'll read it from
Yes, yes.
para number 8, so that we'll understand all the
Paragraph
facts.
8, please.
In page
Plaintiff has
81.
filed a present suit against the defendant to restrain them from committing any trespass, interference, illegal obstruction of scheduled property to the work carried with the defendant in construction of the compound wall or the scheduled property.
No, by granting this order, the entire suit itself is
Allowed. Practically, it amount. That's a prayer.
That is what all of you
Now, then,
accepted before this court.
once it is allowed, my lords, then I will collect memo. I have nothing to more. The suit gets decreed. Nothing more. Now, kindly see in the page 81, top bottom 3 lines. It is the objection raised by the defendants that the vendor of the plaintiff has no title over the suitable property. In that connection, there is SLP number 8621 and the present subject matter suit property is pending for adjudication with the Supreme Court of India. But the plaintiff counsel has submitted to the SLP. The plaintiff is not a party to the petition. Vendor is the person who has filed the SLP. Vendor to the plaintiff has filed the SLP, and vendor says she is in possession of that 6 guntas of land, even before the Supreme Court. In a pleading is there, I'll produce a pleading. Hence, such objection raised by the defendant cannot be considered. The defendants have preferred WP number so and so, order of the Honorable Court and so and so, where the Honorable High Court of Karnataka stated that the party shall maintain status quo until further orders by the trial court with respect to property. However, the respondent here is permitted to fence the property without tampering so and so. For the Honorable High Court of Karnataka has made it clear that fence the property of the respondent, the court will not grant any right, etc. From the perusal about it is clear that even though the High Court has stated the maintain status quo until further orders by the trial court, and permit the plaintiff to fence the property without tampering with the existing structures. Honorable High Court of Karnataka in so and so makes it clear that this court, the permission has been given to the plaintiff to enter the property, but without tampering with the order. As such, the order under IA number 1 so and so, this court has issued tempering the defendant, and the Honorable High Court so and so has permitted the plaintiff to under such circumstances alleged by the plaintiff in order to execute the said order. The defendants are interfering, not letting the plaintiff to construct normal. It is contended that the plaintiff by the counsel of defendants. IA number 1 order is the main prayer of the suit, which is awarded in the interim relief. It may be true that on such period, the appellate court has confirmed the order of the court on IA number. Even the Honorable High Court has given permission to the plaintiff to fence the property without tampering with the existing structure. Under all this circumstances, in WP number so and so, the Honorable High Court of Karnataka has observed defendants have not raised an objection for putting up the fence issued by the court, considering all the existing order of the Honorable High Court has given the permission to fence property. Considering the above facts, it's just necessary to implement.
No, court in the last consider your case to know the already existing structures on the property. It is just necessary to give direction to the defendant to submit the already existing structures in their property of recent photographs.
Recent photographs. And now kindly see the order, my lords. Now, who has to decide whether the recent photograph, whatever I submit, my lords, is correct or not? The practical authorities with the police. Now, everybody will be managing with the police. We will give the photo. The kindly is the operative portion. Defendants are hereby directed to produce recent photographs.
Where are the photographs?
Photos.
Where are the photographs?
Photographs, my lords. I beg to. Please, my lords. Please, page number 10. 104, please. Please. Nam copy code. Every copy code. 104. My lord, there is a road, my lord. Alala, Mr. Photograph. 104, my lords. Your lords may kindly see the road, and there is a small mud road leading with the compound wall gate. That's my property, and that's surrounded by compound wall. And at the end, your lordship will get the school. This is from the school to the road is north south. This is entire property is our property. 22 guntas plus we have another private property of 15 guntas. This is our property is surrounded by the compound wall. Compound wall is of 1971. Kindly the next photograph, my lords. The school building. It's within the compound wall. At the end, your lordship will see this one. Now we have produced this. Now our only fear is we produce this photograph. Our fear is we produce it in the office. Now police aid is given. Police cannot be permitted to decide any dispute, my lords. We give the photo, they will say, no, 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 this is not the photo, etc. The police will say. Therefore, we filed an application under Order 26, Rule 9 to determine the compound wall and the structures within this, so that they don't want to enter. Admitted, according to us, they want to enter into this property and fence, which the Honorable Court always said, don't enter into their property. This is the thing, my lord. This
problem is this, that at this stage, now they want a commission to be appointed. I felt on the basis of his documents, he has to show that he is in possession. You can't ask a commission, court.
No, apart from the commissioner, court says, as per the order of the High Court, no, you shouldn't disturb the other's position. And the petitioner defendant shall place the photographs. Who will monitor this?
No, the reason is still today. It is not their case that I have disturbed or demolished the company. Please see, the entire thing is just, he is likely to, till today I've been following the High Court order, I am only doing my compound work. The first petitioner is an sitting MLA's brother, his son.
No, who will oversee this?
Well,
Who will oversee your construction?
there is no need to oversee. The moment if I do something, he can always move the court and say, listen, produce the next photograph. And say, this is what I produced.
No, court can avoid it instead of passing a final order of this nature. Let the photographs be filed and the court should have passed some order.
The reason is this, the point is that till today, there is not even one statement that I have touched their compound wall or demolished the existing structure. Without even such an allegation, on a hypothetical basis that I am likely to do something in future. Well, courts cannot be asked to, on hypothetical situations, to pass orders. Court says you file a photograph, you know what is the position. If at all there is anything, you will take action. And what more can the court do now? Asking for appointment of a commissioner would amount to delegation of power by the honorable court. I just point out one judgment exactly on this point. This court in a suit for injunction, suit for injunction, possession of the property is a matter to be decided by the court on the basis of the evidence, oral or document. That function cannot be delegated to a commissioner who cannot find out as who is in possession. Now, what they are trying to do is they are trying to get a declaration of title to this. If he says that this is my property, he has no right over this. You take an injunction against me, you can always take an injunction against me saying that don't do it. He himself says, yes, they can a lot of point out. First he says, I don't have any property. Second he says, fence your property. I'm fencing my property. How does it hurt him? Until he makes a submission that he has started work demolishing the compound or he has disturbed the compound. There is no such allegation anywhere. This is just simply keeping the fire burning. That's all. Nothing is happening there.
No, both the trial court as well as the appellate court has dismissed your IA for injunction.
Allowed. My applications are allowed because my injunction is only on my property. I'm not even concerned with this property. He comes forward and says because he wants to move a little. Maybe there is more ground here, some playground for the school, whatever they are doing. So what they want to do is, by this process, they are trying to, now supposing the commissioner goes, what can the commissioner say? Can the commissioner determine the title of each property? No.
No, as for the photographs placed,
If you have not objected to the photographs, I said, we admit the photograph. These are the photographs. You have produced it. If I have done something wrong, point it out. They are not
So
prepared.
shall I record that as per the photographs placed by the court, and as per that you're going to fence your property?
Yes, yes. Yes, please record.
But one aspect, my lords, where is he fencing? Not inside our property. Now let him make it clear, my lord. These photographs are,
So then what was that you accepted before the?
no, but their property is something different. They want to now come inside our property. Let them say if it is the property within the fence.
Then seek clarification of
Your
the,
lords may kindly see what we filed.
then seek the clarification of the, in fact, by giving this order, yeah, the scope of this is already enlarged, where they
No,
have
no, no.
two courts have concurrently held in their favor.
No, injunction is not granted. He can fence without damaging the property already existing. That is the order, my lords.
Let that only be, let that go on.
And my lord, that's why this one court said no police aid application can be filed because he will misuse it, my lords. If the police aid is to file, trial court also says, my lord,
We cannot, the
Police
court,
aid for-
the court by way of an order cannot restrain a party from exercising his rights.
please, but my lord, he cannot enter my property. Kindly see my page 83 in the next case, that injunction court, please. A court commission, my lords. Court commission which we have filed, my lords, please. No, no, he can, now, even now, my lords, they do not say which is their property. Is it within this? Let them make a categorical statement that they are not entering this property, which photographs you have produced.
All this exercise should have been done.
Yeah, exactly.
When you
That I agree.
accepted the order in the writ petition earlier.
May I submit, my lords? Of
Much
course.
water has flown and you can't take
Now, kindly
advantage
see
of your own.
in the second writ petition, one moment, my lords, 83, please, my lords.
Yes.
Page 83 in the second writ petition, next G, where injunction application has been filed. My
Yes.
learned counsel friend's submission is, my lord, that you have never said he is going to enter, etc. Kindly see page 83, my lords. Local investor to inspect the old compound wall, gate of the school already existing within the defendant property, disputed suit property by reporting the same to the Honorable Court, etc. And then kindly see page 84, para 3. We have clearly stated now what is his intention. His intention is to enter our property despite by violating the court's order. Court's order is he can
So
fence.
now we will also put it in the same way. He will make construction in his property. Where is his property as admitted by you in the earlier writ
No,
petition?
but the trial court says, my lord, the photographs should be. The only thing is, photographs are produced. This will lead to law and order because they will influence the police. They will say, no, no, enter. This is my property, my lords. Police should not be adjudicators at that moment, please, my lords. That will lead to a lot of problems. That's why we have. No. Why they are avoiding this? Because police cannot.
Not letting it, if you are letting him do it, why he wants police protection?
No, my lord. The order is, my lord, clear that the. I can.
It's not as though I am not.
No, my lords, property which is in our possession, the trial court also says, this one court says, don't disturb. Consistently, they say.
So we all in the air it is happening. Now this will also be in the air.
We are before the honorable Red Court of Force. I do consider this aspect, my lord. There might have been some errors that have occurred mistake that have occurred because of the submissions of each, my lords. Now I humbly bow down to submit, my lords. Continuing the errors will not be of any use, my lord. It's the great powers of this honorable court which will set aside the errors so that, my lords, at one point of time, my lords, nothing saying that both of us have done anything or
No,
may have made
this
some
court
submissions, my
cannot
lords.
review the order passed by.
No, not reviewing,
And
not
I have
reviewing.
to-
Your lords may kindly see.
I have to pass order in consonance with what are the earlier orders.
Even the earlier order said no application of police aid.
Is it that I will say no.
No application of police aid.
That order, there cannot be that kind of order saying that when you are not letting the other party execute an order passed by the court, he has every right to seek police protection. How can this court say don't take it?
I do consider this when there's a clarity on that point, my lord. But taking the police aid to destroy the court's order cannot be done.
Went the order of the court as it was
As it was.
accepted by the people, by both the parties.
By both the parties, my lords. Now, my lords, when they come, my lords, this now the trial court's order is not on a challenge. The trial court by them, the trial court itself said produce the photographs in the office. In the office means it will not go even to the anybody else. It will be in the office. Then the police will.
I'll ask them to send it to the police.
Only prayer is, my lords. Your lords, kindly. Okay. No, nothing.
I don't know why my elder friend saying police needs, there will be injustice. I don't understand this.
No, I only say, let the courts decide, not the, no, of course, your lordship's anguish, I bow down my language is that there are some apparent errors on the part, my lords, that we submitted, but with the greatest majesty, this all court possesses, my lord, this right time, it's corrected, so that further misuse by any of us is not allowed, my lords. Now only therefore it can be set aside, my lords. If a commission is happened, they will identify, then they can mark it, my lords. They can fence it.
That is enlarging the scope of this.
No, my lord, kindly see for a moment, my lord, page 86, page 84, please, my lord, page 84.
Yes.
My affidavit in support of this. Para 3, elite suit property existing Ayurvedic plants, trees in our property, surrounded with old compound gate, school. Now the plaintiff with the aid of orders and so wants to trespass in the possession of
The
our
court
property.
order is very clear. Defendants are hereby directed to produce recent photographs of existing structures on the property. Thereafter, that means after defendant submitting the recent photographs with regard to the existing structure on the property to the court, the office to issue necessary intimation to the CPI town police station and so and so.
Instead of that, it should have been, my lord, photographs produced, then magistrate, then civil judge should have considered it, then issued the orders, not leaving it to the
What you would-
registry to office to issue the order, my lords.
I'll record their submissions, I'll record your submissions.
That they will not enter, my lords, and the police aid should not be used to enter my property.
That. they
Enter
will
my
not-
property, that's all, my lords.
Yes. Please come.
If required, police can have the assistance of the ADLR also, my lords, if the police wants. No. Otherwise, this will again lead to lot of confusion.
WP number 42. They know, the police also know what is under which compass they have to execute the order. As observed by the court, they will do it.
Your lordship's expectation sometimes may not.
WP
So that
424. No, that's what.
please have
we
some
are-
rider so that, my lord, there is
Yeah,
no.
we have to have that much of
Maybe lordship's
expectation.
rich experience. I know why your lordship saying the anguish is that we consider something earlier, etc. I know that, but let that not decide the final fate, my lord.
WP 4241 of 2026 and WP number 4314 of 2026. The defendant is before this court agreed with the order passed in I number 17 and the other one is I number
16.
I number 16. No. This order is dated. What are the impugned orders dated?
Both date same, my lords. It's, please, my lords, the order dated
Order
28th January 2026.
Agreed with the orders passed on I number 16 and 17. In orders number 326 of 2022 by the first judicial civil judge and JMFC at Chitradurga dated 28th January.
Sorry, one thing, my lords, just my lords, in my duty to bring the kind notice. Why trial court said the photographs is kindly see the second 4314, page number 94 for a moment, my lords. The lordships kindly know the reasoning. Page 94, while dismissing IA number 7 injunction application, my lords, page 94.
94.
Page 94, ink page number 94. 4314. No, sorry. In the writ petition itself, impugned order 4314.
4314.
4314. Para 7 reason starts, my lords. Page 94. After the middle portion, my lords.
94 is not the order.
Page 94, my lords, impugned order.
Hmm.
After the middle portion, first, the separate court commission for localness is not necessary. Instead, as per the direction of this court, defendants can file recent photographs to show so and so existing structure, etc., etc., my lord. Tampers any existing structure at later stage. Digital photographs can put. Hence, appointed court commission will consume more time than taking recent digital photographs and videos of existing structures. This is the reasoning, my lords. And that should not be in the office. Civil judge should consider it and put it on record, then issue the direction along with the photographs.
You file it. Both the videographs and photographs. You've already filed. Videograph and photograph.
I
both
not, no, we have immediately challenged it in the stay,
File
my
it.
lords. We will produce it.
Always file photographs with geotag. Everything is available today.
Photographs, videographs, everything let him file. And
And-
after.
and the order of the
if-
court.
No, you file it by tomorrow. Day after tomorrow, let there be execution of the order.
I will
Order
file it to
copy,
the court, my lord.
order copy by today evening.
Your lordship, kindly permit me to file it to the concerned court. Court should issue it, the order. The office issuing it, my lords. The order.
Has already passed an order directing it. Whatever you file, let it be given to the concern. Copy will be with the court.
And their categorical undertaking now that they will not enter this property, my lord, covered by the photo and video.
Yes.
That your lordship, kindly.
What did you write? Judge and JMFC at Chitradurga, dated 28 January 2026. The petitioner before this court is a defendant in the suit. The respondent herein has filed a suit seeking permanent injunction restraining the petitioners from interfering with the construction of the compound wall. Along with that, he has filed an application seeking ad interim injunction that came to be allowed. The defendant carried this in appeal. Appeal is dismissed by confirming the order passed in the IA. Against that, a writ petition is filed before this court. That is WP number
51.
WP number 23891 of 2024.
Before that, my lord, page 51, my lords.
Oh.
306.
Have filed WP number 306 of 2023 that came to be disposed of by order dated 19 July 2024, whereby this court had modified the order passed by the courts below to the extent that the parties shall maintain status quo until further orders by the trial court in respect to the property concerned. However, respondent is permitted to fence the property concerned without tampering with the already existing structures on the property. Thereafter, when an application is filed for police protection, that was questioned before this court by filing WP number 23891 of 2024 and by order dated 5th September 2024. That writ petition came to be disposed of, wherein the court has observed that
Para 4 also, my lords. Para 4.
Learned counsel for the respondent plaintiff submits that he would advise his client to withdraw the application filed under section 151 CPC seeking police protection. In view of the submissions made by the learned senior counsel for the petition, the learned counsel for respondent number 1 plaintiff, nothing further survives for consideration in this writ petition. It is made clear that respondent number 1 plaintiff shall not press the application seeking police protection, since the petitioner defendants have not raised any objection for putting up a fence in terms of the directions issued by this court. Thereafter, the instant application, that is I number 16, is filed. Sixteen is filed seeking police protection for implementation of the order passed on IAs. It is the case that the petitioner defendant is not permitting the plaintiff to fence his land. By order impugned in these writ petitions, the trial court has passed an order directing the passed an order by allowing IA filed under 151 CPC, and defendants are directed to produce recent photographs of existing structures on the property. After the defendant submitting the photographs, the office is directed to issue necessary intimation to the CPI town police station and police sub-inspector town police station for giving necessary police protection as per the orders passed on IA number 1 and as it is affirmed in WP number 306 of 2023. In that, the defendant filed another application, that is I number 17, seeking under order 26 rule 9 read with section 151 CPC to appoint a court commissioner for local investigation to inspect the old compound wall gate of the school already existing within the defendant's property by reporting the same to the court. That application came to be dismissed by the order impugned, whereby the court has observed that the court has already allowed an application for police protection, and in that there was a direction to the defendant to submit the recent photographs with regard to already existing structures on the property. The recent photographs will help the court to monitor whether the permission given to plaintiff to fence the property is tampered with already existence of the structure property or not. For such purpose, the separate court commissioner for local investigation is not necessary, Instead, as per directions of the court, the defendants can file recent digital photographs to show the court about existence of old compound wall, and after construction of compound wall by plaintiff, the plaintiff tampers any existing structure. The later stage of digital photographs can be compared. Hence, appointing court commissioner will consume more time than taking recent digital photographs and videos of existing structures. For all the reasons, there is no merits in the petition and accordingly dismissed. Agreed thereby that the defendant is before this court. The defendant is before this court, questioning both the orders, that is granting police protection and refusing to appoint a commissioner. Lenesina counsel next para. Lenesina counsel representing the counsel for the petitioner submits that it is a specific case of the defendant that there is no property in existence as alleged by the plaintiff. And it is the case that under the guise of fencing, they are trespassing into their property and trying to make construction. If the commissioner is appointed, the court would be able to understand understand the dispute as well. Under the guise of the order, what the plaintiffs are going to, what are the acts that are going to be done by the plaintiffs. The court, without considering the said application, had just dismissed it, stating that the photographs will be the photographs are submitted. That will be sufficient. Even the court has not taken the pains to look at the photographs. Just asked the petitioner defendant to file the same before the registry. It is submitted that this would create unnecessary confusion, and particularly in the facts and circumstances of the case, where the defendant is stating that there is no property existing. It was, and if this order is executed, it would cause a lot of hardship to the defendant, and all these aspects were not considered by the court. Anything else? Fina counsel. Anything else? Anything else to be recorded?
Anything else is only the page number 97. I was seeing my lord judge, in fact, allowed the application, then said dismiss. Page 97. All confusions because it may kind of set aside everything. Maybe set right once for all. By the all court is my prayer.
That the confusion that's created by passing these kind of orders needs to be clarified by the court in the substantial interest and justice. Next one. Senior counsel representing counsel for the respondent submits that the plaintiff had an injunction by the ad interim injunction by the trial court affirmed by the appellate court, and before this court, the court, as the defendant himself has stated, that he has no objection if the plaintiff funds his land on that petition is disposed of, even when I filed an application for police protection. In that order also, in that case also, the same concession is made before the court that they have no objection if they fence their property. It is submitted that the plaintiff respondent is not encroaching any of the land belonging to the petitioner defendant, and he has been fencing the land belongs to the plaintiff. The court both in both the applications has given the permission to the defendant to place all the digital photographs before the court, so that once the defendant completes fencing the property, he would be able to demonstrate before the court that the petitioner, the plaintiff, has in fact has violated, if at all, if he has violated any of the orders passed by the court. In spite of the same, the petitioner has come before the court. It is submitted that only with an intention to see that the petitioner, the plaintiff, does not fence the property. The defendant is coming up one application after the other, and the petition has to be dismissed. Next one. The prayer. Next prayer. Having heard the counsel, the senior counsels on either side, there is a material on record. The suit itself is filed seeking a relief, seeking injunction restraining the defendant from interfering with the construction of the compound wall. He files an IA seeking the very same relief that was granted by the trial court, which is affirmed by the appellate court. However, before this court, having affirmed in a way, this court also in the writ petition affirmed the said order, wherein the plaintiff is permitted to construct permitted to fence his property, permitted to fence his property. However, apart from that, the parties were directed to maintain status quo. This court has perused the two orders passed by a coordinate bench of this court. In both the cases, in both the orders, it is a submission made before the court by the defendant that they have no objection if they fence their property without interfering with the existing structures of the defendants. And when according to the plaintiff, those orders, as there is a resistance from the defendant, he has filed an application for seeking police protection. The trial court has rightly considered and rightly granted police protection when there is an order, when there is an obstruction for implementation of the order. The court is bound to grant police protection, and the court has rightly granted. Then coming to the application for commissioner, even in that case also, court has passed a reason order stating that if all the digital photographs, videographs are placed before the court, no prejudice would be caused to the defendant, as the defendant would be able to demonstrate before the court that there is any violation of the orders, or contrary to the orders passed by the court and by this court in the writ petition, the plaintiff has made any construction, and the court would take appropriate action for the said disobedience of the orders passed by the court. In those circumstances, when the court has balanced the interest of both the parties, this court is of the view that there is no conformity with the order passed by the court which seeks interference of this court. Hence, the court is passing the following order. This court do not find any reasons to interfere with the orders impugned. However, it is made clear that the petitioner by tomorrow shall place the digital photographs as well as the videographs before the court, before the registry of the trial court.
And the plaintiff's undertaking that he will not construct in my property in those photographs. Plaintiff's undertaking.
As undertaken before this court by the plaintiff, they shall strictly adhere to the earlier orders passed in the writ petition by a coordinate bench of this court, and that is sufficient.
He will not make any construction inside the defendant's property.
That is what is the order.
No.
What is the order?
He will not make any construction inside the property shown in the photographs. He admitted that photographs he will not interfere. That your last make it clear, my lords. That makes a lot of difference.
The plaintiff shall not make any construction contrary to the undertaking they made before the earlier benches and also before this court, that they will not make any construction in the defendant's property.
In the photographs shown before the honorable court.
As for the photographs.
As for the photographs. Yes, now it comes.
Your lordship said, will not make any construction in the defendant's property.
Yes.
Your lordship is giving him a window for one more litigation. Please say,
otherwise, he will make construction inside
the order. As per the order.
No, otherwise, he will make construction inside my property. He will enter.
As per the photographs, as undertaken before the court, they will be making construction as per the photographs placed before the court. He said so.
No, which photograph? He will not make construction in the photographs.
That is already there.
No, your lordship made this point, my lords. Now he said, therefore your lordship is disposing of. He said, no, let me make my point clear. No. What they want is, they don't want this point to come. They're disturbing wherever this point is coming, my lord. Not to make any construction. No, in the property shown in the photographs. That he has undertaken. Therefore, your lordship said, I will dispose of the matter. That was undertaking. We can't. Yes.
Number 7.
No.
Yes.
Yes, yes, that was a specific undertaking.
No, let
Photograph
him-
kodi. Photograph kodi. That otherwise they will enter and say, High Court has today, High Court has asked me, permitted me to enter the property.
He's responding. I think you should permit him to say something.
But he's not, please, please, please.
Yes.
Please, please.
The photographs were produced now to show what the property is, where my property is, what is there. The photographs don't say that all the land surrounding the photographs belongs to me. He is now trying to create, so I said, by Lordship
this-
says, I will abide by my undertaking that I will not demolish it or disturb these constructions. I will construct on my property and strictly follow the undertakings given to this court earlier also.
No, my lords, he specifically undertook that he will not enter the property. That's why he produced the photographs. It's the same photograph I am producing. Now he cannot, there are trees. He will say, I will cut this tree. No, that he can't do, my lord. That will lead to lot of havoc. Now armed with the police will come, sir. Police, High Court has permitted me. That's undertaking specific.
Has not permitted anything.
No, but-
High Court has only said.
No, no,
The
your-
order passed by the court is correct.
Please.
He has to, as per the earlier orders, he has to.
No, my lords, in the course of submissions, when the photos got produced, he said, I am not going to enter into this property.
Who will understand what about those photographs and all? Court has asked you to place the photographs, digital photographs, and court will do the inquiry, not.
And
for
let these
court.
photographs also go to the concerned police along with the order, my lords. Whatever you have submitted, let it go along with the order.
I said you will do it by tomorrow to the court.
Yes, yes. No,
They
along
will-
with the order.
They will in turn will do it.
No, that's, my lord, there is no order that these photographs should also go along with the intimation to the police.
That's what the court.
That your lordship, Mikhail.
No, that's what the
Last
order.
para, I-
That's what the order says. I think you should read the order again, senior counsel.
my
The
lord,
court
your
said
lordship
so.
directed me to produce tomorrow.
No. I said so, but in that order, the court said that these should be immediately forwarded to the police.
With great respect, my lords, what the honorable court has said is, but let me, no, he wants to enter my property. Kindly see, my lords, kindly see the order, my lords. That means, no, he wants to enter my property. That's why, whenever I submit that, my learned friend is blocking me. No, I want to read it with permission, my lord. That by, after the recipient submit the recent photographs, the regards so and so, office to issue intimation. The photograph should be sent is not there. It will be in the office only. Your lordship may kindly see, telling the police, you give police protection for fencing. Which property? That should also go, my lords.
Cell number
Your lordship may
7.
kindly direct that the photographs also should accompany the order, my lords.
Next.
Please.
7. Syed Salman Khomeini, petitioner.
There is for the petition in this case, your lordship.
Yes, what do you say?
As I received the instructions.
Lordship is as per the
Take
Annexure,
the property, keep those mics, court officer.
Mike,
Yes.
One Muniswamy has filed objections for a connection of power supply, my lord, regarding the title, my lord. Based on such objections, we have not granted.
What is that?
One Muniswamy has filed the objections regarding stating that he is the owner of the property.
So what did you do? You have to call him, you have to ask him, you have to look at the documents.
Yes, my lord. The suit is pending before the trial court, my lord. It was
What is the
decree.
suit?
Now the RFA, they filed the RFA.
No,
Yes, my lord.
when you give a power connection,
Yes,
there are
ma'am.
certain, you have your own protocol.
Yes, my lord.
If you place those documents.
Yes, my lord.
The remaining, when there is no order from any court,
Yes,
that,
ma'am.
that can't stop you from granting.
No, my lord. The thing,
Mere pendency of a civil suit is not a ground.
yes, my lord. My lord,
Has he placed any document of title in his favor?
he has produced the document, my
Then
lord.
that is sufficient for you.
My lord, the Muniswamy has filed the objection that title is not belonging.
Then
to-
you get it. No, if
Yes,
this
ma'am.
suit goes on for 10 years, if
Yes,
you don't give a power connection, what will happen? So you look into the documents.
Yes, ma'am.
As per your regulations.
Yes, my lord.
If he fulfills,
Yes, ma'am.
notwithstanding the fact that the
Yes,
suit
ma'am.
is pending, you should consider.
Yes, ma'am. Will do. My
Please
lord,
come.
and RFA, there is a status quo order is passed, my lord. regarding-
Status of what?
Status quo of the suit scheduled property, not to change anything, my lord, regarding the.
Giving electricity connection
Yes.
is not changing the nature of the property.
Yes, ma'am.
The,
Lordship is that the suit, the RFA is only for partition suit, your lordship is. This is they
The-
filed the partition suit.
the present writ petition is filed. Seeking the following prayer. If the facts of the case are that the petition is absolute owner of the immobile property bearing municipal number 50 situated with Topanahalli, HL, second stage, Bangalore, measuring east to west 45 feet and north to south 90 feet, totally measuring 44,050 square feet, which he has acquired with the petitioner. with the partition date. That BBMP has also transferred Kata in favor of the petitioner, has issued the Kata certificate and extracted in his name. The petitioner wanted to make a construction and obtained a sanction plan for construction of a residential building in the scheduled property from the BBMP. The petitioner has started construction in accordance with the sanction plan. Then the petitioner has approached the respondent number 2 for the electricity connection. The respondent number 2 has taken the application and the petitioner has paid the charges. Meanwhile, the respondent number 2 has given the acknowledgement that the Muniswamy M will file the objection that the objection that the electricity shall not be provided to the said premises. Agreed thereby, the petition is before this court and counsel appearing for the petitioner submits that when an application is made with the owner of the property for the supply of electricity for the connection, the respondents have to look at as per the procedure contemplated under the, what are those called?
Karnataka electricity supply conditions.
Karnataka electricity supply conditions, and they shall grant the connection. Just because there is civil dispute between the petitioner and others are pending, that cannot be a ground for the petitioners to reject the case. Next part. When counsel appearing for the respondent submits that there is a title dispute between the petitioner and one Muniswamy, and he has given a complaint. He has given a representation that in view of the disputes between them and the suits that are pending, and also an order of status quo that is granted by the court in a
RFA. Yes, RFA 530 of 2012.
530 of 2012. The connection, they should not give the electricity connection to the petitioner. As such, the said application of the petitioner was not considered. Next part. Having got the counsels on either side, there is some material on record. The petitioner, basing on certain documents, alleging to be stated that he is a owner of the property, he obtained the permission from the BBMP and also sought for electricity connection. When an application is filed seeking a electricity connection, they are bound by the so and so, that Karnataka so and so rules. And as per that, the respondents have to proceed, and they cannot, basing on some complaint, they cannot keep the application of the petitioner pending or refuse to grant the connection. If the petitioner fulfills all the criteria as per the so and so, the respondent shall consider the application and pass orders. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the respondents to consider the case of the petitioner for respect of electricity connection in respect of premises number so and so, in accordance with law and as per the so and so.
Much
Yes.
obliged.
Serial number 8. Keshar Bhagat for petitioner.
I am for the petitioner. Matter was listed yesterday. Your Lordship asked me to produce the translated copy of the I under Order 26 Rule 9 and the objection filed by me, my lord.
Check that.
Well, as petitioners being the plaintiff filed a suit for declaration and injunction, my lord, regarding suit schedule property in survey number 56/1 and 56/3 measuring 10 guntas. I acquired the property as per 1926 sale deed, my lord. At the first instance, my lord, I filed the application under Order 39 Rule 1 and 2, and defendants have filed application under Order 26 Rule 9. That was dismissed by the trial court, against which they have not preferred any appeal. again a second round of litigation, they filed the very same application. That was allowed without giving any reasoning, my lord.
This property belongs to Harijan colony with the malicious intention of defrauding the defendants who are Harijans and illegally acquiring this property. He has brought this suit.
Well, no, my lord. My lord, same contention was taken, same application was filed. It was rejected on earlier round of litigation.
Where is that order?
Yes, my lord. I will take your lordship, my lord. At page 42, in appeal, order 39 rule 1 and 2, I was granted the injunction that was challenged by them only, my lord. At page annexure G, page 33 may be kindly seen, my lord.
No, what is the connection between that and this? Because MA is affirmed. That
No, my
doesn't
lord.
mean that he cannot make an application.
No, my lord. Regarding 26(9) application filed, it was dismissed. That is, finding is recorded, my lord.
That's what
Successive application.
filing an application during the pendence for any when the matter is for set down for an injunction, interim injunction, and when the matter is now at the fag end of the trial, it makes a lot of difference.
My lord, there is no other case made
Same
out
parameters
patent.
do not apply at this stage.
But 26(9), what I'm telling, it was rejected on merit, not on the ground that you filed
On
after.
merit,
Yes,
on merit at what stage?
yes, but at the
When
beginning of the
granting of,
trial.
at the time of granting injunction.
Yes, madam.
So it will not preclude him for filing an application at this stage.
Yes, madam. Now, important observation made by the appellate court and this honorable court also confirmed, madam, that I have produced the judgment.
No, I understand. Let it be confirmed. So it
Yes,
will not be a res judicator that he can't file another application. That
madam.
is, at the
Yes,
time of granting injunction, question of appointment of an advocate commissioner doesn't, I mean, the commissioner won't arise.
yes, madam. They thought for it was rejected, madam. That
No,
is not challenged.
you have to independently convince the court
Yes, madam.
using this order that
Yes,
it is not maintainable. Yes.
yes, well,
Yes.
I will give me my 2 minutes time, but I will convince your lordship regarding that, my lord.
Yes.
This is a suit for injunction against the person who are interfering with the peaceful possession and enjoyment of the suit schedule property. They are not claiming that their property belonging to them. They are claiming property belong to somebody else. How they can
No,
maintain?
they say that property acquired for the Harijan community, and these people are the Harijans and residing in that is their case.
Yes, so it is like a public interest litigation. How it is in my, I have specifically stated, produced a sale deed. Sale deed is having a boundary. It is 1926 sale deed. I adduced the
So
evidence.
all the more good that that would be when you're so confident about all that. What
Well,
will happen if it
what
is
I'm
upheld?
telling, that is a to determine the possession. Fishing for the evidence after the fact is not permissible, my lord.
We'll see once the refundant comes. Yes, notice.
Cell number 9.
Still, then status
Notice.
quo will be ordered regarding the order, my lord. My lord, they have already issued the commissioner warrant, my lord.
Yes, notice.
9. Bhuvan KP.
Appear for my lord. After the death of defendant number 10, LRs have come on record. I filed a application order 6 rule 17 by way of counterclaim. My lord, the Supreme
Take
Court
that.
judgment referred, but this judgment are not applicable to our case. Kindly, the first 2022 judgment, my lord, order 2 rule 2. If the two suits has been
So
be
according to you, you can take an inconsistent stand from
my
the
father.
original defendant.
No, my lord, there is no inconsistency because, my lord, my uncle purchased the property in the year 1968, survey number 14/2. My father filed, we are the owner of
Come to the which paragraph of this order?
judgment, my lord. B, my lord, civil for 22 citations, my lord, 2022. B, civil procedure order 6 rule 17, order 2 rule 2, bar under order rule 22, inapplicability of two amendments sought in the existing suit. If the two suits and the relief claimed wherein are based on the same cause of action, that the subsequent suit will become barred under order rule 2. However, order 2 rule 2 cannot apply to amendment which is sought an existing suit. These are suit for specific performance. They sought two suits are there. So therefore, my lord, this judgment is not applicable. The defendant, plaintiff has referred this judgment. And order 2 rule 2 also clearly explained in para 46 and 50.
Next statement, Ashok Kumar Kalra.
Yes, my lord, that one is a second judgment, Ashok Kumar's, regarding counterclaim. After framing of issues, the defendant cannot file.
See, let's
Yes.
see that. Where is it?
Para 17 to 21, my lord.
Let's see.
The time limitation for filing the counterclaim is not explicitly provided by the legislature. Rather, only limitation as to the occurral of the cause of action is provided, as noted in the above precedents. Further complications stem from the fact that there is a possibility of amending the written statement. However, we can state that the right to file a counterclaim in suit explicitly limited
When was
by
the suit filed?
2017. My father died 2025.
When was this counterclaim?
Counterclaim recently after we came on
You
record.
can tell the year and date are relevant,
Yes, ma'am.
not
Yes, madam.
recently.
Yes, ma'am. 6/6/2025.
25,
Yes, ma'am.
7 years. And what is the relief you're seeking?
So relief seeking to declare we are the absolute owner of the property, that is a client schedule property, 14 survey number
So you're
14.
seeking declaration
Declaration.
after 7 years by way of a counterclaim.
Yes, my lord. My father also filed a written statement stating that so we are the owner of the property, we purchased the property, so suit liable to be dismissed.
Please
Only
come to para 17. That is the answer to your submissions.
judgment, my lord.
No, this judgment, this Ashok Kumar Kalra.
Yes, yes, ma'am. Embargo provided for occurral of cause of action under Order 8 Rule 6A. Having said so, this does not mean the counterclaim can be filed at any time after filing the written statement, as counterclaim is treated to be blind. Generally, it need to first of all comply with the limitation provided under Limitation 1963 as time barred. Suits cannot be entertained under the guise of the counterclaim just because of the fact that the cause of action arose as per the parameters after Order 8 Rule 6A. As discussed by us in the proceedings paragraphs, the whole delivering substantial justice, particularly the purpose of introducing Rule 6A in Order 8 of CPC is to avoid multiplicity of proceedings by driving the parties to file a separate suit and see that dispute between the parties is decided finally. If the provision is interpreted in such a way to allow delayed filing of the counterclaim, the provision itself becomes redundant and the purpose for which the amendment is made will be defeated, and ultimately it leads to flagrant miscarriage of justice. At the same time, there cannot be rigid and hyper-technical approach that the provision stipulates that the counterclaim has to be filed along with the written statement, and beyond that, the court has no power.
Yes.
My lord, because if my father filed after delayed, that cannot be entertained. We came on record in the 2025. Immediately we filed. We have a right to file additional written statement. By way of additional written statement, we sought by way of amendment as a counterclaim. This is we are entitled to.
Please come.
That judgment, my lord, yesterday I
I
referred.
thought I'll also refer to
Yes.
that. Agreed with the order passed in. orders passed in the IA number 24, invoice number 223 2017, dated 26 March 2026, by the Principal Civil Judge and JMFC Tarkare. The petitioner dated 26 March 2026. The petitioner defendant is before this court. The respondent herein has filed a suit for declaration and consequential relief of permanent injunction in respect to the property bearing survey number 14/2, measuring 2 acres 11 guntas. The suit was filed on 7/7/2017, and the petitioner's father, who was the defendant, had filed his written statement. He died in the year 2024. On 28/1/2024, the petitioners herein were recorded as LRs of the deceased defendant. Then on 6/6/2025, the incident application is filed seeking amendment of the a counterclaim, seeking amendment of the written statement, and also by seeking the counterclaim. That came to be dismissed by order impugned. While dismissing the application, the court has observed that on an elaboration of the proposed amendment now sought to be made to the existing written statement, it is seen that the defendant number 10, who had filed the written statement in the suit, expired during the pendency of the proceedings. His legal representatives have subsequently brought on record and submitted before the court that they had no written statement to file. Subsequently, by way of the present application, they are seeking to introduce a counterclaim for declaration of title to the suit property in their favor. The court has considered the judgment of the Apex Court in Ashok Kalra versus Surendra Agnihotri, reported in 2022 SAC 394, and observed that in the light of the said judgment, that the outer limit for raising a counterclaim in a suit would be before the framing of issues. The deceased defendant number 10 had contested the suit from the year 2017 till his death, but never sought to raise a counterclaim. Now that the matter has reached the stage of arguments, his legal representatives cannot at this stage seek to introduce a counterclaim in the suit, and accordingly dismiss the application filed under Order 7 Rule 11. Land counsel appearing for the petitioner submits that the father has made a factual basis in his written statement. After his death in the year 2024, they have come on record in 2025, and they have a right to file a additional written statement. And also, they have sought for a counterclaim. The court ought to have allowed the said application. He relied on a judgment of the Bombay High Court in case of Neelkant versus Samarkand, reported in laws within brackets Bombay 2016, 7, volume 7, page 127. He relied on paragraph number
5 and 6.
Paragraph number
5 and 6.
5, 6, and 7. Relying on this, it is submitted that the court ought to have allowed the application. It is submitted that the court had relied on the judgments of the Apex Court in case of Life Insurance Corporation of India versus Sanjeev Builders Private Limited and another, reported in 2022 16 SEC 1, and also the judgment in Ashok Kumar Kalra versus Wind CDR Surendra Agnihotri and others, reported in 2022 SEC 394. It is submitted that the said is those two cases are not applicable to the facts of the present case. It is submitted that unless and until this counterclaim is allowed, it would cause a lot of hardship to the plaintiff. Next one. Having got the counsel for the petitioner, peruse the material on record. The suit is one for declaration, which is filed in the year 2017. The father contested the suit. Father of the petitioner contested the suit from 2017 to 2024 for 7 years. He has never sought for a counterclaim. And then these petitioners are they are brought on record as a legal representatives of the deceased. The contention of the land counsel for the petitioner is that when once they came on record in the year 2024, 2025, they filed this application. As they have a right to file the additional written statement, they have a right to file the counterclaim, and these aspects were not considered. In the court, this court do not find force in the argument of the land counsel for the petitioner. The Honorable Apex Court in Ashok Kumar Kalra referred Supra has elaborately discussed about the law in this regard. Para 17 to 21 are relevant, which are already discussed by the trial court. Please extract that. This judgment, the judgment makes it very clear that even if the counterclaim is filed within the limitation period, the trial court has to exercise its discretion to balance between the right to speedy trial and right to file counterclaim. Further, the court has observed that to file a counterclaim in a suit is explicitly limited by the embargo provided for the accrual of the cause of action under Order 8 Rule 6A. Having said so, that does not mean that counterclaim can be filed at any time after filing of the written statement. As counterclaim is treated to be plain, generally it needs to be first of all be compliant with the limitation provided under the Limitation Act, as a time-barred suit cannot be entertained under the guise of the counterclaim just because of the fact that the cause of action arose as per the parameters of Order 8 Rule 6A. Coming to the facts of the case, the cause of action to file the counterclaim, that is the seeking declaration, has already arose for the defendant in the year 2017 itself, when they have filed their written statement. Now, after 7 years, they cannot be permitted to raise the counterclaim by filing this amendment, by filing this petition seeking amendment of the pleadings. In the light of the law laid down in Ashok Kumar Kalra's case, the court has rightly considered and rightly dismissed the petition, and this court finds no reasons to interfere. Accordingly dismissed.
This observation not to be considered in merits.
This court has not expressed anything on the merits of the matter. None of the expressions of this court shall be construed. None of the observations shall be construed as an expression of this court, and the court shall decide the same in accordance with law. Yes, next.
This court, my lord, on
First,
11/8/2026.
questioning the
On 11/8/2026, my lord, this court directed to get specific instructions whether the deputy commissioner has got a power to determine the compensation, my lord. I'm filing the memo, my lord, along with the circulars issued by the Ministry of Power, my lord. Copy is also served to the petitioner's counsel, my lord.
Yes.
Lord, I appear for the respondent number 1 in this matter. I filed my wakalat yesterday, my lord. Petitioner may be directed to serve a set of
1 minute. 1 minute.
Document number 1, my lord. Page 4, document number 1.
Have you seen this?
Yes, I'm seen this, my lord. On two grounds, my lord, some filed this petition. One is, my lord, deputy commissioner is not having power to determine the compensation.
That is now answered.
Now, my lord, as per section 16(3), my lords, The act, central act says that was only the district judge is, my lord, the proper authority to determine the compensation. Plus, one more submission is, my lord, recently I obtained,
What do you say on this?
plus, unless until the 16(3) amends, my lord, the circular, my lord, cannot override the act, my lord.
And that also should be questioned by you. The
Pardon?
circulars should be questioned by you, saying that.
Plus, I am not aware of the circular, my lord. We are the poor agriculturists, my lord.
No. Your advocate is there.
Now, my lord, now only, my lord, I have to amend the writ petition.
Give the papers to her.
Yes.
So and so shall serve the copy of the writ petition on the council appearing for the first respondent. Yes.
May I request for a date?
When do you want?
Plus, next week, my lord.
This is a matter.
Cell number 11. P. Vishwanath Shetty for petitioner.
Huh?
Two
Is
days
there stay in this? No, are you arguing or are you seeking adjournment?
ಅದಕ್ಕೆ 2 ದಿವಸ ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ ಅದರಿಂದ 2 days time I'm seeking.
No 2 days time. Let's this matter on 1st of September.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನ ಅಲ್ಲ one submission ಇಲ್ಲ. See, on 25th there is a matter set down for cash examination. ಅದರಿಂದ ಇಲ್ಲ ಅಂತ I will argue the matter, please. My court.
1st of September. Yes, next.
Cell number 12. J. Raj D for petitioner. Raj Prabhu S for Kevita.
Very sorry, second of in this, second of September. My lords, in this case, I would just take your lordship attention to one of the Supreme Court judgment, my lords. It talks about.
What is this?
This is for IA number 3 and IA number 4, which got dismissed by the execution court. One is for the recall of the arrest warrant, and one more application was filed under section 51, read with section 151.
I think this matter is adjourned only on the ground that I wanted you to get instructions.
Yes, ma'am. My lords, I'll just take only 2 minutes, my lords. Then I'll give the memo as well.
I am not at all going on to the merits of the matter at all. When these kind of
the
matters
constitutional right itself would be infringed.
It will be constitutional right, and you also your obligation to pay the money.
That
I will say, provided you pay the money. In all these kind of money matters.
I will make a submission that as well, my lords. I'll just take I will take only 2 minutes, my lords. I'll not take much time.
No, that legal question, I'm aware of it.
Just 2 minutes, my lords.
Take it. For your satisfaction, I'll look into it and.
Yes, my lords. Yes. And I will definitely make an undertaking as well. That what is the amount that I can deposit, just to show my bona fides.
In that case, let us not. This is all Jolly Burgess case and all. We are aware of it.
My lords, here just I would like to take you to the relevant paragraphs, my lords. Page number 4, my lords. Page number 4.
This is a celebrated judgment of Justice Krishna. Everybody knows. Why do you want to burden the court with the time
my lords, in this section 51 is the constitutional right, my lords. My submission because
that we all know. After knowing all that, what is that you are going to?
Yes, my lords. I will take you to 3 memos that has been filed by the petitioner, my lords.
Yes.
Sorry, filed by the decree holder at page number 146. It starts, my lords. I'll just take you to page number 146 minutes.
Yes.
As in this, the first memo that has been filed by the decree holder, my lords. I would like to take you only to the tabulation, my lords. The tabulation 1 is damages of rupees 20,000 from 1/10/2014 to 5/3/2020. Amounting to rupees 13,20,000. Then again, cost of the suit 14,812. Cleaning of wastages for rupees 40,000. Repairing of flooring rupees 48,000. Arrears of rent as on October 2014 as per para 2 of the judgment 1,17,670. Interest at the rate of 9% per annum for the damages in 65 months 48,750. Interest at the rate of 9% per annum for the arrears of rent 95,310. Total arrears due is 16,84,542. Now I'll take you to the second memo that has been filed, my lords, by the same decree holder. In the second memo, that is a H2, annexure H2, page number 149, my lords. Damages of rupees 20,000 from 1/10/2014 till 31/9/2023. In the previous memo, he has stated that 20,000 damages from 1/10/2014 to 5/3/2020. Then in the next memo, it is varying, my lords. Then again coming to cost of the suit, then again cleaning of vestiges. Then again he has put column number 6 and 7. The decree does not talk anything about the
Come to the
interest.
decree.
Page number 113, my lords. Page number 113. I would like to read the prayer portion of the plain, my lords. To ejectment of the defendant from the suit scheduled property, directing the defendant to quit, vacate, deliver, and hand over vacant portion of the scheduled property to the plaintiff, forthwith arrears of rent, security charges.
So, forget about other things. From 1/10/2024, you are supposed to pay rent at 20,000 per month.
Damages.
Whatever it is.
Whatever it is.
20,000.
Yes, ma'am.
So how much it comes?
110
My lords,
2014.
now,
my lords.
now
110
14.
2014. Thank you.
2014. My lords, I would like to take you to paragraph number B at page number 114, what they had filed in the plain, my lords. For mean profit at the rate of rupees 20,000 per month from the date of termination of the tenancy, that is from 1/10/2014 to.
When did did he vacate the premises?
He
No, my
vacated the
lords.
premises.
When did he
My lords,
vacate?
Court
on
commissioner was
3/3
appointed, and the court commissioner was appointed on 29/11/24, my lords. Sorry, 13/9/2023. The position was delivered
My
to
lords,
the
here only my
the court
submission.
commissioner itself, my lords.
No, my lords, my submission here is, in the first memo, as far as the tabulation is concerned.
Forget about all that. We are not going into that. Now you please tell the court,
No, no.
as per the judgment and decree, don't try to look at what has he said. No, please show your bona fides.
Yes.
So.
My
From 10/10/20.
my lords, two submissions with regard to the decree that has been passed by the decree court. Insofar as the page number 115 is concerned, it is further ordered and decreed that the defendant is further directed to pay the damages at the rate of rupees 20,000 from 1/10/2014 till he quit and deliver the vacant portion of social property.
Yes.
So my contention before the execution court is that I have already handed over the portion on 3/3/2020 and I have given the acknowledgement as well as the photograph of the decree holder standing in the said
So
premises.
please stop there.
Yes, ma'am.
We'll accept that. You have given
Yes,
me
ma'am.
for,
Yes,
for, for the time being.
Yes, ma'am.
On 3/3/2020, you have given the position.
Yes, ma'am.
So 2014 to 2020, what is the amount?
No, I will come to that submission, my lords. I'll come to that submission.
I
will-
think court's time.
No,
is-
no, my
you
lords,
can straightaway come to
my
the
lords,
point.
my lords, coming to the court fee on damages to be collected from 1/10/2014, my lords. Once he is filing the execution petition, he has not deposited the court fees. His prayer is on the execution petition is only for the recovery of 14,812. Please go into page number 45, my lord. 45 of the order sheet. He himself has submitted before the court that he wants to recover only 14,812. Then thereupon, amendment application I'll take you, my lord. Just for 2 minutes, I'll take your lordship to the amendment application that he has filed under order 6
Having
rule.
enjoyed the property without even paying anything, and you say.
No,
now
my
that,
lords, no, I have already filed, I have already filed my memo for calculation before the
How much
trial
is the
court.
amount coming? Please tell the court.
Yes, ma'am, yes.
Is it only 14,000? Total amount
No,
is
no, no, no,
14,000?
not that is not our condition, my lord. Just, this is already there on the record, my lord.
Yes.
Plus in this is the first set of objections that we had filed before the trial court, my lords. I will take you,
Straightaway come
no,
to
no,
the
I will take you to,
figure.
no, no, I will take you to the last page number 5, my lords. Page number 5 and 6. Page number 6. Page number 7, my lords.
How much is that amount?
That is coming to 9,900,000.
When are you paying?
Well, already I paid 2 lakh rupees.
When you will pay?
I will to show my bona fides.
Have only
My lords.
13 lakhs 20,000.
No, no. It is the admitted amount which has been recorded in the order sheet as well, my lords, by the trial court, means by the execution court. They have recorded in the order sheet as well what is the admitted amount, and they were just giving direction to pay the said admitted amount. But anyway, that adjudication, let it happen before the execution court. To show my bona fides, I will deposit 2 lakh rupees, my lords. 2 lakhs have already paid. 2 lakh admitted amount is about 9,900,000.
Total amount is 20.
My last 9,900,000 because they have calculated the interest component as well. So that we will let because I already filed an application under section 47 that the execution court cannot go beyond the decree, my lords, where the application is still pending. So let me be given an opportunity to address my argument on the said IN number 5, my lords. I will deposit 2 lakh rupees just to show my bona fides, my lord. Because the
It doesn't show your bona fides at all by saying that you will pay 2 lakhs. It doesn't show at all.
well, as your lordship can.
I'll pass orders. If you're not understanding what the court is saying, yes.
No, my lords, let the time be given for, because we are even.
First of all, amount itself is running into lakhs. And now when you say that admitted is 9 lakhs, at least stick to that and pay the amount. Or else I'm going to.
No, my lords, we are ready. We even it was referred to the DLSA, my lords. We were ready to settle the matter for 10 lakh rupees, my lords. We were ready.
Pay that 8 lakhs rupees. Now you have paid already 2 lakhs.
2 lakhs.
You can't, because taking
Yes, my
advantage
lord.
of the process
Let
and
the time
technicalities of the
be
court, you can't.
Yes, my lord.
You can't harass other person.
I will take instruction from my client and we will submit.
Yes.
We will pay the 10 lakh rupees. Let the time be given.
And I'll say, I'll not simply like it is not your client is also there. I'll record that.
He is the reason.
And I'll say that if you don't pay, if you don't pay, he has to pay the consequences of it. He has to face, not that he's buying the time from the court.
Regarding the 10 lakh rupees, let the time be given, madam. Initially, now he is ready with the amount of 2 lakh rupees will deposit. Let the time be given for the remaining portion of the amount.
When?
Maybe 3 months time, madam.
That you have to file an undertaking affidavit. File it. I will look into it and pass orders tomorrow, day after tomorrow, whenever you come up.
Let it be taken up tomorrow. We will file the undertaking as well. And we will deposit, we will give the undertaking. Much obeyed.
Yes. Tomorrow in the first place.
I appear for the petition on this matter, madam.
It is, unless if it's taken up at 2:30, I will file the undertaking today itself.
Tomorrow. Why those letters are? How many times I have to tell you? Take action. Take action against the concern. Take action. But what is today? What is today? Huh? Take action. And don't come to the chamber again with this. Take action against the concern. It is already enough time is given. At least 10-15 times I must have called. Take action against whoever it is. Give him a memo. Next.
13, I appear for the petitioner in this matter.
One nimisha, sir. Pass over serial number 3. Pass over serial number 3.
A letter is addressed by the learned judge seeking extension of time. This court by order dated 14/11/2025 directed the court to dispose of the matter within a period of 4 months. Now another extension of 3 months is sought. As this letter is addressed on 14th July 2026, already 1 month time is elapsed. This court is granting another 2 months, that is by October 27th, the matter has to be disposed of. Yes.
Serial number 13.
Appear for the petition in this matter.
Vivek, yes.
Yes.
Appear for the petition in this matter.
Yes.
The matter pertains to illegal disconnection of the temporary sanction of power that was provided to the petitioner's
Yes, what happened?
building.
What are your instructions?
My lord, there is a building violation of the construction on the instructions of the Panchayat Development Officer, they have disconnected. Since there is a violation of the.
What, have they issued any notice or they will not do anything?
No.
Instructions are there on the basis of.
No, problem is, if there is deviation, the local authority will issue a notice to them.
Certainly.
Will take action for demolition. At the time of demolition, if required, you will disconnect the power supply. No,
Certainly.
unfortunately, no, nothing is being done by the local authority. Everything you will only do. They will not
Certainly.
even issue notice.
My instructions are there. They were requested in writing, since there is a building violation, construction is violation of as per the sanction.
They're not following due process under the law, your lordships, but they're harassing all the citizens like this by, taking coercive steps. Your lordships
When was the permission taken by you?
in the year 2025, your lordships, March 2025. The building is nothing but a PG for students. They've already come and
Have you received any notice from the Panchayat?
Yes, your lordships. At Annexure F, I've already annexed it. It's a picture.
What happened to that?
I've taken necessary steps. I've already given my representation to them.
Have they passed any order?
No, not yet. Not yet.
I think Bescom has lot of time for all this, which the local authority has not.
It's end of the day, students, your lordships, who are
As
put
per their
to
request,
justice.
they have disconnected.
No, what
Our
I'm not
lordships.
able to understand is at this stage, why should you react? Or
Correct.
no, they have to pass an order. They gave a show cause notice to them. They have responded. They should pass an order. And at an appropriate time, if your resistance is required, you will do. Not at this stage. Please
I'm
come.
told, my lord, it's within the permissible limits of
As per the
the
GO.
bylaws. Yes, yes, your lordships. Because petitioner number 3 himself is an engineer by profession. So he himself gives instruction to me saying that I can submit to this court that it is within the permissible limits. And he undertakes
The
to
writ
compel
petition
the.
following prayer. The facts of the case are petitioners of the absolute joint owners of the property bearing site number 314, Gram Panchayat 314 in survey number 46, measuring 5 acres 29 guntas. Within the limits of Chilu Gram Panchayat, situated at Devara Kagalahalli village, Araholi Hobli, Kankapura Taluk. They purchased the property by a registered sale deed dated 18/10/2024, which was registered at the office of the sub-registrar Kankapura. And the Kata is also effected in their name. And they have obtained the necessary permission from the competent authority. And the permission was granted on 21/3/2025. And he has commenced the construction. They have also obtained the temporary electricity supply. And they have submitted all the requisite documents. Now they have disconnected the power supply without any prior. No notice is issued.
My instructions are at the request of
How can it be without even notice?
the temporary connection.
No notice.
Thing with regard to temporary connection.
But however, they collect the invoices regularly, your lordships, that have been complained of from 2025. Have been paying the bills.
It is a case that they have been regularly paying the electricity charges without any default. It is submitted. It is stated that respondent number 3, by notice dated 6/7/2026, has issued a notice saying that the building was not constructed as per the sanction plan, and the petitioner was directed to immediately stop the construction and to furnish the necessary documents relating to the construction within 3 days, failing which coercive action will be initiated. It is a case that the petitioner had immediately submitted his reply to the said show cause notice, and so far no orders are passed by the respondents. In the meantime, the Bescom has disconnected the power supply. Then council submits that even as per the GO issued by the state government. It's a circular or the GO?
It is a GO.
It's a GO issued by the state government. The land of the petitioner is within the permissive limits.
Sure.
And they have already made an application in that regard. It is submitted that this action of the respondent is high-handed, and there will be direction to the respondents to forthwith restore the power supply. Land council appearing for the respondent submits that basing on the letter addressed for the local authority, they have disconnected the power supply. It is submitted that they are bound to do the same, even as per the judgment of the recent judgment of the Honorable Supreme Court. It is submitted that there is absolutely no illegality with the order, with the action of the respondents. Having heard the counsel on either side, there is a material non-record. The petitioner has sought for the building permission and made construction, assuming that there are deviations or the petitioner has made construction contrary to the sanction plan. Already the local authority has issued the notice. Petitioner has submitted his explanation. No further orders are passed. Now basing on such a communication from the local authority to the BESCOM has now disconnected the power supply. Even if for the purpose of, after the final order is passed, and for the purpose of, for any other purpose, if such an letter is addressed, and by issuing a show cause notice to the petitioner, the respondent had acted on that, it would be altogether a different situation. But in the facts and circumstances, it was the respondents ought not to have disconnected the power supply in this manner, when the issue with regard to the unauthorized construction is very much pending before the local authority. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the BESCOM to forthwith restore the power supply. Number two, if any further, once the local authority passes an order, and for any other purpose, if they receive a communication from the local authority, this order will not preclude them from acting in accordance with law.
Number 14, Arvind Reddy M. H. for petitioner.
Will I appear for the petitioner in this case, my lord?
Lordship, I'm appearing for the respondent.
Yeah.
The respondent filed a commercial suit, my lord, without complying with section 12A. There's no pre-institution mediation. But the commercial court allowed the suit to proceed and issued notice to me. When notice was issued to me, my lords, I filed an application under Order 7, Rule 11, saying that, my lords, the suit should be dismissed because, my lords, that section 12A is mandatory. And there was no real urgency in this matter, which would require this matter to be proceeded with.
That is a ground for rejecting the plaint.
That is a ground for rejecting the plaint, my lord.
No, court must have given the reasons why they are dispensing with Valley. But that has to be questioned.
But that was an ex parte order, my lords. When I filed an Order 7, Rule 11 application, the court said, my lord, there is an ex parte order that has been passed without hearing me, and therefore I am not going to revisit that order. My lord, and my application has not been considered at all. My lord, this is contrary, my lords, to the law laid down by the Supreme Court. I'll just show that. But my lords,
to the order impugned, where is that?
Let's kindly look at the order, my lord. The impugned order is dated 16/7/2026.
Page number?
Page 76, my lord. The order sheet starts, my lord, at page 43, and take your lordships, my lords, to the order at page 74. Lord, orders on IA number 15.
No, what will happen is, court has considered the case of the plaintiff and has dispensed with the requirement of Pelle. In that case, now you file a rejection, seeking rejection. What will happen to that order?
Well, that is an ex parte order.
No, whatever it is, it's an order.
It is an order. It is an order.
An order. It is staring at you even right now.
Yes.
At you in the even if you can have questioned it later.
Yes.
But how can an Order 7, Rule 11, when there is a judicial order, court has exercised its discretion?
I'll straight away take your lordships to the Supreme Court judgment.
Unless and until court finds fault with such a discretion.
Yes.
Vested by the court.
What happens, my lord, is this. Firstly, my lord, section 12A is a mandatory provision.
Yes.
That is the rule. Pre-institution mediation is the rule. The exception, my lord, is in cases of extreme urgency, that requirement can be dispensed with. But, my lords, for that reasons have to be set out. My lords, kindly see the reasons.
That is set out in the earlier order.
Yes, my lords, kindly see that order, my lords, 4/10/2025.
No, before this, you show me the legal portion that in spite of an order dispensing with the 12A, and that order, even after you enter appearance, that not being questioned, independently Order 7, Rule 11 will be filed.
Can be filed. My lords, kindly, my lords, Supreme Court judgment. My lords, I'll just take your lordships to the case law. My lord, what happens is, my lords, any order that is passed, my lords, on an ex parte basis must be capable of being reviewed, reconsidered after notice is issued to the other party. Otherwise, what happens, my lord, is an order like this, which is an important order, without hearing me, cannot be passed and cannot attain finality. Let's kindly see the Supreme Court judgment. I'll just take your lordship's note because the issue is now well covered by 3 Supreme Court judgments. I won't take your lordship's note to party automation, which once said that Section 12A is mandatory. That is now the law dictated by the Supreme Court. Kindly see the
12A
latest
is
judgment.
mandatory, discretion is with the court, or
Yes.
a judicial
Yes,
discretion.
yes. So kindly consider the latest judgment, my lord, which is the third judgment in this compilation, 2025 Supreme Court.
Page number?
It starts at page number. Dhanbad. Yes. Hmm? No. Which page is this judgment?
What is the, which case it is?
The third judgment.
Dhanbad fuels.
Dhanbad. It's 2025 Supreme Court. My lords could kindly have paragraph 39 first. I'll just take your lordships to 2 or 3 paragraphs of this judgment. Paragraph 39.
Page 51, Dhanbad.
Yes, my lord. The aim and object of Section 12A.
Para number?
39, my lord. It's internal page 447, my lord. Which page number? No.
Yes.
Paragraph 39. The aim and object of Section 12A is to ensure that before a commercial dispute is filed before the court, the alternative means of dissolution are adopted so that resolution, it must be, that's not dissolution, so that only genuine cases come before the courts. The said procedure has been introduced to decongest the regular courts. This is the object, my lords. Now kindly see paragraph 45. The position of law is well settled that a plaint may be rejected under Order 7, Rule 11 if any of the conditions specified therein are fulfilled. The decision in partial automation recognized this principle and stipulated that beginning 28/2022, any suit instituted under the 2015 Act without complying with Section 12A must meet with the fate of rejection of plaint under Order 7, Rule 11. So therefore, my lords, Order 7, Rule 11 can be filed only after notice is issued to be after the defendant enters appearance. Otherwise, at the ex parte stage, there can be no question of Order 7, Rule 11. It is also pertinent to observe that under Order 7, Rule 11, no time period within which the plaint may be rejected has been stipulated. The power to reject a plaint thus can be exercised at any stage of the suit. Now, my lords, kindly come to the conclusions and directions at paragraph 71.
Yes.
Internal page 459. 71.7, my lord. The courts must also be wary of the fact that the urgent interim relief must not be merely an unfounded excuse.
Paragraph number?
71.7, my lord. Page 459.
Yes.
The courts must also be wary of the fact that the urgent interim relief must not merely be an unfounded excuse by the plaintiff to bypass the mandatory requirement of Section 12A of the 2015 Act. And then kindly see 72.1, which is the most important. If the 72.1 minutes, if the suit is instituted on or after the date of the decision in partial automation, that is 28/2022, without complying with,
this conclusion can be read from 71 from the beginning.
Yes, ma'am. So I'll read it. 71. In light of the aforesaid discussion, we summarize our findings as under. The decision of this court in partial automation lays down the correct position of law as regards Section 12A of the 2015 Act by holding it to be mandatory in nature. As held in paragraph 104 of the decision in partial automation, declaration of the mandatory nature of Section 12A relates back to the date of the amending Act. But this is a question about whether partial automation operates prospectively or retrospectively. In partial automation, it was specifically held that a suit can be dismissed without compliance, and that operates prospectively.
71.4.
71.4. A suit which contemplates an urgent interim relief may be filed under the 2015 Act without first resorting to mediation as prescribed under Section 12A of the 2015 Act. Unlike Section 82 of the CPC, leave of the court is not required to be obtained before filing a suit without complying with Section 12A of the 2015 Act. The test for urgent interim relief is if on an examination of the nature and subject matter of the suit and the cause of action, the prayer of urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint of the plaintiff. The court must also be wary of the fact that the urgent interim relief must not be merely an unfounded excuse by the plaintiff to bypass the mandatory requirement of Section 12A of the 2015 Act. Even if the urgent interim relief ultimately comes to be denied, the suit of the plaintiff may be proceeded with without compliance under section 12A if the test for urgent interim relief is satisfied notwithstanding the suits instituted without complying with section 12A of the 2015 Act prior to 28/2022 cannot be rejected under Order 7, Rule 11 on the ground of non-compliance with section 12A unless they fall within the exceptions stipulated in so and partial automation. In suits instituted without complying with section 12A of the 2015 Act prior to 28/2022, which are pending adjudication, well, this is the pre-partial automation judgments, well, so I'll skip that. Thus the answer, paragraph 72, thus the answer to the question formulated by us, whether a suit filed without complying with section 12A of the 2015 Act must be dismissed or be kept in abeyance with a direction to the parties to explore mediation is as follows. 72.1. If the suit is instituted on or after the date of the decision in partial automation without complying with section 12A of the 2015 Act, then it must meet with rejection under Order 7, Rule 11, either on an application by the defendant or suo motu by the court. So, Melons, I specifically have a right.
For this, I'm not able to understand.
Yes.
Why will the court take it as so? Because the court has appreciated the necessity for that he is entitled for an injunction order, without going through this 12A. Court has passed an order.
Yes. On an ex parte basis. So therefore, that decision is considered to be a provisional decision. But there must be a full-fledged consideration of that, after the respondent or the defendant is heard. Otherwise, what happens is this ex parte order that is being passed by the court has the character of finality, and that is an order of final that becomes final in nature without hearing the defendant. That cannot be the case. It is for that reason, that the Supreme Court says, if the suit is instituted, and if it is done without complying with section 12A, then it must meet with rejection under Order 7, Rule 11, either on an application by the defendant or suo motu by the court. If the court allows the matter to proceed, issues notice to me, etc., then my right to file an Order 7, Rule 11 application must necessarily be preserved. Otherwise, what happens is merely on the say of the plaintiff, and if the court says that, okay, issue notice to the defendant, without hearing me, an important provision, section 12A, is bypassed, and that order has the character of finality without hearing me. An ex parte order then has the effect of finality, and this is exactly what the trial court says. Because I've made a determination on 4/10/2025 without hearing you, I am not going to consider your Order 7, Rule 11 application. This is what the court says.
Yes.
Your Lordship, may be permitted to
appear virtually. I'm so sorry, before my learned friend starts, but just one more judgment, if I could just show the approach taken by the Madras High Court. Of course, this is only persuasive. This is not a binding judgment.
Yes.
This was a converse case, where the commercial court says that, sorry, we will not entertain this unless you institute mediation. This matter was challenged before the Madras High Court. Kindly see what the Madras High Court does. In paragraph 18, it says that this matter needs to be reconsidered afresh because there seems to be some urgency, etc. But kindly see paragraph 18.
Yes.
Since this order is passed before numbering of the suit and without hearing the respondent defendant, this court hastens to add that the order passed in the civil division petition will not come in the way of the defendant raising an objection regarding non-compliance of procedure under section 12A of the Commercial Courts Act 2015. In case after entering appearance, the respondent or the defendant files any application for rejection of the plaint complaining of non-compliance of section 12A of the Commercial Courts Act, the same shall be considered on its own merits by giving adequate opportunity to both the parties without being influenced by anything said in the order. So therefore, both parties must be heard. I'm not saying that the court doesn't have the power. Of course, it has the power. If there is a necessary case, where there is extreme urgency, pre-institution mediation can be dispensed with. But that order that is made on an ex parte basis necessarily has to be reviewed after the defendant enters appearance, and the defendant must have the opportunity to point out to the court that there was no genuine urgency at all.
Yes. Yes, counsel for the respondent.
Your Lordship, before I submit on this application, may I just be permitted to explain what is the background of the facts, Your Lordship? The respondent is the plaintiff before the trial court, Your Lordship. These totally. Your Lordship, on the question of law.
In this facts are not relevant. Only thing is application and Order 7 Rule 11. Court said I will not consider it because already I've given I have given him the permission to know that 12A is already Yes.
Yes, Your Lordship, the reason why I'm referring to the facts, Your Lordship, is that whatever submissions learned senior is making before this honorable court as to an opportunity should have been given and there was no urgency that was contemplated, none of these grounds are stated in the application which is filed for rejection of the plaint. Your Lordship, the objective of Section 12A of the Commercial Court Act was, as recorded by the Honorable Supreme Court, that if in the event the parties can mutually amicably resolve a dispute, then that kind of settlement has to be given effect to. In the present case, Your Lordship, the plaintiff has given 5 crores of rupees to the defendant for purchase of properties. Now, the defendant has not sold the properties to us, so all that I've done is return the money back, and the defendant has made partial payment. Balance amount has not been paid to me, which is why money recovery suit insofar as balance payment. Now, the urgent relief which we had sought for is, Your Lordship, these assets which were promised to be sold to me, these defendants were contemplating to sell.
Going into the merits of the matter, whether the court
Your
can
Lordship, this is
consider
not on
Order
merits.
7 Rule 11.
This is not, Your Lordship, this is not
Whether
on
the
merits.
court can consider Order 7 Rule 11 petition or not is the only question.
Yes, Your Lordship, in this case, as of 4th October 2025, the plaintiff had filed application seeking dispensation of going before the pre-institution mediation. Your Lordship, Section 12A states that in case of urgency that is pleaded by the plaintiff in its application, if there are reasons, then the court can grant dispensation.
No dispute on that.
There is no dispute. Your Lordship, this consideration of whether there is urgent relief or not, this is a matter between plaintiff and the court, Your Lordship. There is no proposition of law which states that the defendant has to be given an opportunity of hearing before deciding whether there is an urgency contemplated in the law or not. Your Lordship, if I'm not had the benefit of the Madras High Court judgment which Learned Senior has given, I will make my submissions in that regard, Your Lordship. But the judgment which Learned Senior referred to, may I just draw Your Lordship's attention to the very same judgment, just 2 paragraphs if I may refer to state why Order 7 Rule 11 application cannot be filed by the defendants after the Honorable Commercial Court has already considered and applied its mind under Section 12A and dispensed with the institution of pre-mediation, Your Lordship. Para number 71.4, Your Lordship. A suit which contemplates an urgent interim relief may be filed under 71.4.
What he read now?
Yes. What are the distinguishing features, Your Lordship? This, in the present case, Dhanbad Fuels, Your Lordship, it was not a case where the court had granted dispensation under Section 12A and the defendant has disputed. This was a case where the defendant said that totally there is non-compliance of Section 12A. In this context, the Honorable Supreme Court in Para 71.4 has categorically stated a suit which contemplates an urgent interim relief may be filed under the 2015 Act without first resorting to mediation as prescribed under Section 12A of the 2015 Act, Your Lordship. It is not a case, this is not a case where we have not sought for dispensation. We have sought for dispensation, the Honorable Court has considered, passed a well-reasoned order. Then second, Your Lordship, if I may draw Your Lordship's attention to Para 71.6. The test for urgent interim relief is if, on an examination of the nature and the subject matter of the suit and the cause of action, the prayer of the urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint of the plaintiff. All that can be considered is whether in my pleadings, in the plaint or in the application seeking dispensation of compliance of 12A, whether I have stated as a plaintiff what is the urgency. In the present case, I have stated that both in my plaint as well as the affidavit accompanying application seeking dispensation of Section 12A. But in the application for rejection of the plaint, Your Lordship, a very untenable stand is taken that I have not stated any such grounds, Your Lordship. That is false. And the last point to be noted, Your Lordship, Para 71.10 of the Honorable Supreme Court, where it is stated, in suits instituted without complying with Section 12A of the 2015 Act prior to 28/2022, which are pending for adjudication. Lordship, the entire directions of the Honorable Supreme Court that plaints can be rejected is exclusively in situation where section 12A has not been complied with. In the present case, we have complied with section 12A, your lordship. There is a reasoned order. And also, your lordship, why the learned commercial court in the present case, while dismissing the application under order 7 rule 11, what the commercial court has taken into consideration is when the conduct of the defendant, that the suit was filed in October 2025, until March, they have not filed their written statement, your lordship. They've repeatedly sought for it. They were placed ex parte, then they were recalled, WS not filed, time given. Now I filed an after they filed the WS, I filed an application for summary judgment. Now after I lead elaborate arguments on why summary judgment should be given, then they filed this application, your lordship. It is only with an intent to protect the proceedings. Kindly see that application also, your lordship.
All that's irrelevant. It's a very simple question. You're going all around, not required all the facts. Whether an ex parte order that is granted,
Yes.
that is the
Yes.
that is given to you, whether he can question it under order 7 to 11 is the only question.
No, your lord.
If
In
it-
my respectful,
Yes,
respectful
that is
submission,
sufficient. Yes,
and
Lord
your-
reserve. Yes.
Your lordship, one more submission, if I may be
Yes.
permitted to make. In
Yes.
this case, the writ petition has been filed by 5 petitioners, but whereas the petitioner number 5 who has been arraigned, he's not even filed the application, your lordship. He has no locus standi to question it. He's in fact been placed ex parte, your lordship. That also may be recorded.
Also, it'll be restricted on the part of petitions 1 to 4, Malad. I'll file a memo to that effect. I was not aware of that.
Files. Wakalat is
Yes.
given by all 1 to
Yes,
5.
yes, I agree. Malad.
Or 2 to 5. One is.
File a memo.
I'll file a memo, right?
Yes. Heard reserved. Yes, next.
Your lordship, if I may just make one submission, your lordship, with respect to the judgment which learned senior has referred to Madras High Court. In the event, if I find any other judgment, may I just be
Please give it
permitted?
to the court officer.
Yes, obliged.
Question GA for petitioner Umesh S.
For respondent bill, kindly pass over.
Passover will not be called.
Any date may be.
Let's, this is a matter where I have been, this is a stay that is operating in their favor. 2 points, lots. This is a transfer petition filed by the.
Who is the petitioner?
Lots. I'm the petitioner.
Oh.
I'm the petitioner.
So
There's a
stay is operating in their favor.
in the trial court, lots.
Oh.
So I've challenged that stay application. Now the issue is this. I may just submit this point. They have filed a miscellaneous petition, lots. This is a matter that is pending before Anikal Court, where I have a decree in my favor in the year 2016, which is suit for declaration and title and not to interfere in my possession against that has been subsisting even till today against the said respondent. Now he has filed a case for suit for specific performance. He, along with the vendor, there was a collusive decree.
They're seeking time now. Even if you argue again, they'll.
No, I'm only submitting. So at least if Lords may post it for tomorrow, I have no difficulty in.
Please, my lord.
Tomorrow. And again, if tomorrow you ask for Passover, I will not grant. I'll hear the matter.
No, my lord. I will
Grateful.
not.
Great.
Tomorrow.
Number 16.
16 is what you called, I think, now.
15.
15, yes, 16, yes.
16 for
Submission, my
admission,
lord.
Dada Jayanti CS.
Admittedly, the suit is for declaration, my lord. The extent is 1 acre of land. Only because the plaintiff says that he has not paid the ad valorem court fee. Admittedly, the suit is for.
Come to your IA.
The order, my lord, I have not.
IA seeking, this is order 7 to 11.
Yes, for payment
That
of.
your IA in support
I have
of
not
the.
produced, my lord, because.
Not that how come they filed.
No, my
allowed
lord,
you to
because
post?
the order is very clear that the learned judge says that it is a suit for declaration. No, my lord, everything is there in the order, so that is why
It's
I
not
didn't.
that. Whenever you question an order, application objections are the basic things which needs to be filed, not that whether the court has extracted or not.
Because it is, my lord,
Up to in an application under order 7 to 11.
only for payment of court fee, my lord. Only for payment of court fee, that is what.
Court said that is not a ground to reject the plaint.
No, it says because the plaintiff has pleaded that the conversion order has been obtained behind the back of the plaintiff. My lord, whatever it is, behind the back or back, my lord, it is admittedly a suit for declaration. Point number 1. Point number 2, I have produced a conversion order.
We'll ask the court to frame an issue in that regard.
And point number 3, it is within the civil vicinity. Admittedly, it is, but
That's what I'm saying. Let the
yes.
court frame an
At
issue
least
in
as a
that
preliminary,
regard.
because it is waste of time, my lord.
Whatever is the issue, ultimately you are not going to pay. He has to pay the court fees. He'll pay the court fees.
No, the learned says that let the trial go on because it is behind the back of the plaintiff. So let the plaintiff prove that it was behind the back of the.
No,
So
ultimately, it's the duty of the court to see that the proper court fees is paid.
Therefore, at least preliminary issue regarding.
Issue will be framed.
No, at least preliminary issue, my lord, because it is.
No, if it requires any evidence.
My lord, I have produced the conversion order. My lord, I have produced the conversion
Agreed with
order.
orders passed on I number 4 in OS number 5756 of 2021, dated 15th November 2024. The defendant is before this court. The suit is filed for the accreditation of title. In that, an application is filed under Order 7 to 11 seeking rejection of the plaint on the ground that the plaint does not disclose cause of action and the plaint is undervalued. That came to be rejected by order impugned. While rejecting the application, the court has observed that a cause of action is a bundle of facts that gives rise to the right to sue. It is a legal claim that allows a party to seek judicial relief. On perusal of the plaintiff amendments, it reveals that the plaintiff contends that the suit property was granted to his father under the Mysore (Personal and Miscellaneous Inam Abolition Act 1954 on 35/1960. The plaintiff, after the death of his father, has inherited the property and is in possession of the scheduled property. Further states that the defendants have
Illegally got the revenue, my lord.
illegally got the revenue records transferred to the name of the defendant's father and behind the back of the plaintiff have obtained the conversion order. Further, the contents of the encumbrance certificate from 14/14/1957 till 18/1/2021 discloses nil encumbrance. The court observed that the plaintiff has produced the encumbrance certificate from 1957 till 2021. On perusal of the said documents, it does not reflect the sale deed executed in respect to the suit scheduled property in favor of Muni Reddy. The court observes that the plaintiff has described the scheduled property as agricultural land and claims to be in possession of the property and valued the suit under Section 24D and 26C of the Karnataka Court Fees and Suit Valuation Act. According to the defendants, it has to be valued under Section 24B and the court fee shall be paid on 1/2 of the market value of the property or 1 rupee, 1 rupee or 1,000, whichever is higher. As it is the case that the conversion is behind the back of the plaintiff, the plaintiff has rightly valued the suit under Section 24D of the Karnataka Court Fees and Suit Valuation Act. Further, what is the market value of the suit land is to be determined during the course of the trial. If the court fee is paid on the market value, it can always be recovered later, even at the time of disposal of the suit, and accordingly dismiss the application filed under Order 7 to 11. When counsel appearing for the petitioner submits that when the petitioner is placed before the court, the conversion of the property as it is in the within the municipal limits, the property value has to be done accordingly, but the court, without considering the same, had dismissed the application. It is submitted that the suit has been rejected on that ground. Next, having heard the counsel for the petitioner, there is a material on record. According to the petitioner, it's a converted land. According to the defendant, according to the plaintiff respondent, it is obtained behind his back. Whatever it is, when once the property is a converted property, as on the date of the filing of the suit has to be valued accordingly. The court has also observed that it will be decided in the due course. In that view of the matter, this court is passing the following order. The The writ petition is disposed of, directing the court to frame an issue with regard to the court fees and decide the same in accordance with law. Then coming to the notices after her arguments, though notice is served on the respondent, there is no wakalat is filed on his behalf, on behalf of the respondent. Yes, next.
Much obliged.
Cell number 17, Mohan S. for petitioner, MB Chandrachud for R1.
Appearing for petitioner in this case. The application filed by defendant number 3 under Art 7 Rule 11 was dismissed by the trial court by not observing properly the awareness made in the written statement.
What is the suit for?
The suit for partition.
And what is the ground for rejection?
The ground that Your Lordship may kindly see the plaintiff has clearly taken a contention that they are having an ancestral property measuring 2 acres in survey number 88/2. And after it was belongs to their father. It is not dispute. It is not in dispute. After the demise of the father of the plaintiff, the plaintiff and defendant number 1 and 2 continue to be in joint possession enjoyment. And thereafter, they have agreed to sell that property. Lordship, I draw the attention of Your Lordship, page number 12, my lord.
No, before
Page number 12 of
before
plaint.
that, let me look at your application order 7 to 11.
Yes, my lord.
Where is that?
Page 24. Page number 24, my lord. Application. Order 7 Rule 11A and D of the Code of Civil Procedure for rejection of plaint.
Who are you, or the member of the family or a purchaser?
It is the family matter. That's what I am requesting Your Lordship to take page number 12.
No, I'm looking at 25.
25.
Defendant number 3 is not a family member.
That's what I'm asking, whether he's a family member or a purchaser.
No, that is not my case, my lord. My case is that
What I'm asking is, who are you? What is
I am
your...
the purchaser of the property.
Yes. Please
Purchaser.
read para 3.
Para
3. At page 25.
3. I submit that in the plaint, the plaintiff has already stated that para 3 and 4 that they are having an ancestral property bearing survey number 88/P2 measuring 2 acres situated at Kannur village, Kudur Hobli, Magdi Taluk, and that the plaintiff and the defendant number 1 have entered into an agreement of sale of the said land for a sum of rupees 82 lakhs, out of which received a sum of rupees 31,50,000 as advance sale consideration amount, and the remaining amount, a sum of rupees 50,50,000, remains with the purchaser. The plaintiff, without claiming the amount remaining, which remains with the purchaser, the said suit has been filed. Such being the circumstance, the suit filed by the plaintiff is liable to be dismissed.
Oh, where is the plaint?
Plaint awareness.
Come to the cause
Yes.
title.
Page number 12. Para number 3.
Plaintiff is Manjula. Defendant number 1, your defendant number 3.
And defendant number 3.
Who has entered into an agreement of sale?
No, I am not. No, that is not my case, my lord. That is, I am not the purchaser. This property, kindly permit me to read this para, my lord. Clearly understood. The suit schedule property is altogether different. It is not an ancestral property. It is the property purchased by the defendant number 1 out of the sale consideration amount received by him under the sale agreement. This property was not sold. This property was in existence as on the date of filing of the suit. The plaintiff is not claiming this amount. Her contention is that out of the amount received by her, received under the sale agreement, the suit schedule property was purchased in the name of defendant number 1. That's what she is claiming share in that property. Subsequently, this property was also sold. The remaining amount is with the purchaser. In the remaining amount, the plaintiff is having right. Out of the remaining amount, that property was purchased. That property is not the ancestral property. The subject matter of the partition suit is not the ancestral property. That is the property purchased by the defendant number 1 out of the sale consideration amount received under the sale agreement. The remaining amount is with the purchaser. The plaintiff is not claiming that amount. Instead of claiming that amount, she is claiming share in the property purchased by the defendant number 1 out of the sale consideration amount. In that para, they have clearly stated.
Let me read the plaint.
Para number 12. It is submitted that the land measuring 2 acre in survey number 88P2, Kannur Kudur Hobli, Magdi Taluk, originally belongs to Hanumantarayappa, son of Hanumantaya, father of the plaintiff and defendant number 1. During the lifetime of said Hanumantappa, he and his children, plaintiff and the defendant number 1, were in peaceful possession and enjoyment of the said property. Subsequent to the death of the said Hanumantrayappa, the plaintiff and defendant number 1 continued in the joint over the said property. Kata of the said property mutated in the name of the defendant number 1 on the basis of inheritance under MR so and so. It is submitted that the plaintiff and defendant number 1 decided to sell the land measuring 2 acres in survey number 88/P2 of Kannur village so and so, and decided to purchase the land nearby the place. That is not the subject matter. That is not the family joint family property. Land nearby land in favor of Mrityunjaya Swami, nearby land, nearby place where the defendant number 1 residing according to the plaintiff. The defendant number 1 have agreed to sell the said land in favor of Mrityunjaya Swami, son of so and so, for 82 lakhs, and they have received advance sale consideration amount of 31,50,000 and executed an agreement to sell dated 27/2018 in favor of Mrityunjaya Swami. And it is submitted that from the said sale consideration amount, the property is more fully described in the schedule of the plaint herein. After refer to the social property, which consists of areca nut trees, coconut trees, farmhouse, and so on so. This property has been sold in terms of sale dated 22/5/2019. That is the case of the plaintiff. In the remaining amount, she is not claiming any share. And this property has been purchased out of the said amount. According to her, that portion of property, that amount is not included in the plaint. Only with an intention to disturb this purchaser, this suit has been filed. And moreover, your Lordship McKinley, by not appreciating these are all the aspects, the trial court has observed that on a different footing it was observed. In para
Agreement
reasoning.
of sale executed for 82 lakhs.
No, make submissions.
1 minute. Yes.
Amount of rupees 31,50,000 was issued. Sale deed was executed on 22/5/2019. Thereafter, the present suit scheduled property was purchased out of the sale consideration received by selling the ancestral property. That is why I am seeking partition. My father had an ancestral property. Myself and my brother succeeded the said
What has happened to the remaining 40 lakhs?
It was received by all the defendants, plaintiff and defendant number.
There is no such argument.
Nowhere it's stated.
No, it is said, what we said is, out of the advance amount, the suit scheduled property was purchased.
What are the other properties?
It's only property. Only one property inherited by us from my father.
I understand.
This is the
That
only property
according
purchased.
to you, out of 80 lakhs sale consideration, a
Please.
part of it is paid. With the part of it, the suit scheduled property is purchased. What has happened to the, because
That has been shared by the plaintiff and the defendant.
where do you say that?
Next paragraph I said, sale deed was executed subsequently. It's not specifically worded. The sale deed was executed after the sale agreement was said.
No, out of this 80 lakhs,
Please.
for 40 lakhs, assuming just for the number, 40 lakhs, you have purchased this property.
Please.
Another 40 lakhs is there.
Shared,
What happened to that?
Shared between plaintiff and the defendant number 1.
Where do you get that?
That was not said in the plaint. The fact remains the property was inherited by my father was sold. This is the property purchased out of the sale consideration amount received from the sale of the property of my father. He is a subsequent purchaser, my brother. This is how the problem starts. He can't claim as a successful purchaser of the property in question. He can't say that it is not an ancestral property. His contention is this property was purchased in the name of the defendant number 1. It is not the joint family property. That was the contention.
Because it's a bona fide purchaser, the property latest purchased in the year 2020 in the name of a brother. Why will anybody think that it is a joint family property?
No, my submission. There is no dispute about the purchase of the property by my.
What is the case of the defendant? What did the defendant say?
No, that is the case. It is self-acquired property of the defendant number 1. And nowhere he said what is the date of the sale deed, what is the sale consideration. Kindly see the entire written statement. He never said the date of sale deed. Never disclosed about the sale deed. Even in the application filed before the trial court for rejection of the plaint, nowhere in the affidavit he said he purchased the property under the sale deed dated so and so.
Even to consider
Nowhere said.
whatever you are saying, it has to go for a trial.
Yeah.
No, my lord,
Can that be
subsequently what had
decided now?
happened, subsequently, in the return state, in the plaint, it has been clearly stated that under the sale agreement, it was agreed to sell. Subsequently, they have sold the same property in favor of some other person.
That
Very same
can be
property.
questioned by my brother. It is not by the other defendant.
No, but any of the, is it filed by them?
Jointly, plaintiff and defendant jointly sold the property in favor of some other person.
Certainly, that is the property
On
which was sold.
33/2022, the very same property, and what they have sold the property out of the sale consideration that they have purchased. The very same property has been sold in favor of some other person.
No, even taking it on record, is it a ground for rejecting the plaint?
Yes, ma'am.
How?
All the properties of the family is not included. The amount remains with them. That is not included. In my return statement also clearly taken, one more site is also there in the name of defendant number 1. That property is also not included.
Under which?
To that effect.
Under which proviso to order 7 to 11, this is on that ground the plaint
No,
has
on the plaint averment itself, the cause of action made has been created. There is no cause of action. For the remaining amount, no suit is being filed. She is not claiming any share in that amount. Even though as on the date of filing of the suit, that debt is remains with the purchaser.
It has to be questioned by my
As
mother.
for the plaint averments.
My brother, he cannot question that.
Agreed with the order passed in I number 2, invoice number 857 of 2014 dated 9th April 2025 by the first additional senior civil judge and CJ and Kumkor. The defendant is before this court. The respondent herein has filed a suit for partition. In the said suit, the petitioner, who is the defendant number 3, had filed an application under order 7 to 11 A and D to reject the plaint. That came to be dismissed by order impugned. While dismissing the application, the court has observed that upon perusal of the entire plaint, it is found that the plaintiff and the first defendant are none other than the brother and sister. The land bearing survey number 88/P2 is situated to be sold in the year 2018. By the time it was sold, the plaintiff had already become a co-partner in view of Section 6 of the Hindu Succession Act. Succession Amendment Act 2005. Moreover, the suit property is stated to have been purchased from the joint family nucleus, that is, out of the consideration amount which was got by the defendant number 1 after selling their aforesaid property. In order to adjudicate all these facts and issue, the trial is required. Only after the completion of the trial that the said facts can be decided. Therefore, the court had rejected the application and consider the petition submits that.
This did draw the attention of the trial court has taken the fact into consideration that the entire property was sold. The agreement was not taken into consideration.
The land counsel appearing for the petitioner submits that as per the plaint, they wanted to sell the property and they've entered into an agreement of sale. According to them, from the whatever is the earnest money received in the said agreement, by way of the said agreement, they purchased the sue scheduled property, which was later sold to the petitioner herein by the brother. Land counsel for the petitioner submits that there is no there is no question of partition, as the property stands in the name of the defendant, which is purchased by him, which is a self-acquired property, and he has sold it to the defendant. It is submitted that only with an intention, the suit is a collusive suit, whereby the property which is sold in favor of the petitioner is only added as a property when there are other family, the joint family properties. It is submitted that the court, this is a case that this is the petitioner could make out a case that it's that the plaint has to be rejected, as there is no cause of action for the plaintiff to file the suit. But all these aspects were not appreciated by the court, and only on the ground that it's a matter of trial, the court has dismissed the application. Next paragraph. And counsel appearing for the respondent submits that according to the plaintiff, the property is purchased after selling the joint family property, and then she is entitled for partition in the said property. Whether the property is purchased from after selling the joint family property or not will be that can be demonstrated by deducing evidence by the plaintiff in the course of trial, and at this stage the case cannot be the plaint cannot be rejected on this ground. It is submitted that The trial court has rightly dismissed the application and there are no grounds to interfere. Next, having heard the counsels on either side, there is a material on record. The petitioner, according to the petitioner, there is no defendant, there is no cause of action to file the suit. The property in the present suit is not a joint family property and it belongs to the defendant number one. According to the plaintiff, the property is purchased by defendant number one after selling the joint family proceeds for family property, and out of the said sale proceeds, he has purchased this property. According to the petitioner, what happened to the other amount? There is no discussion. And this is only when there are other properties, the suit has been filed only in respect of this property. This is a collusive suit. As far as the cause of action for the plaintiff to file the suit, they have made out a cause of action that it is a property belonging to the joint family, and she is entitled, as it is purchased from the joint family proceeds, she is entitled for partition. With regard to whether it is a collusive suit, whether it is a joint family property or not, or all these aspects are matter of trial and that cannot be decided at the threshold, and other contentions that are raised by the petitioner cannot be the grounds on which the court can dismiss an application filed under Order 7 Rule 11 in that view of the matter. This court finds no reasons to interfere. Accordingly dismissed.
Time bound may kindly fix me.
Here is the suit.
22, 24.
24 suits, no time bound. Yes, next.
I am the purchaser, bona fide purchaser. They're not allowing me to enjoy the property peacefully. That's what. On one or the other reason, they are disturbing me.
Yes.
H. Maregowda for petitioner 18.
Counsel for petitioner, Your Honor, petitioner seek.
File this matter on 3/4/2025. Notice to the respondent.
No, Your Honor, actually it was WP and it was converted to CRP then.
Whatever it is, there is no urgency at this point. Notice to the respondent's hand summons.
Your Honor, I seek for a stay in Your Honor.
I will not grant stay now. That is what I'm saying. Yes.
Cell number 19. Samir Hussain for petitioner.
Yes, under Order 7 Rule 11(1)(a) and D, suit for where injunction. My case is, my lords, I had filed a writ petition impleading the plaintiff in the case, and an order was passed by this honorable court saying that both the parties must be present for an inspection by the ADLR for the demarcation of the boundaries. That happened on 1st February 2025. The suit is filed on 15/6/2025, my lords, without disclosing in the plaint the fact of filing an order passed by the writ petition inter partes and the survey that took place with the ADLR. On that ground, my lords, application is filed under Order 7 Rule 11D for rejection of the plaint on the ground there is suppression of material fact, my lords. That application is rejected by the Honorable Trial Court. I am before my lords. Lords, kindly see the order of the court, my lords, at page number 22 and 23, my lords.
What is the suit for?
Suit for bare injunction that I should not interfere with his possession.
What is that report?
This says that's my property. Survey number which is measured is my property, and there's no trace of his house or anything like that in that report, my lords.
No, and in which proceedings the
writ proceedings? Writ proceedings. Writ proceedings. I have Annex F, my lords, kindly see.
Writ proceedings, survey was conducted.
Please, my lords, there was an order by the High Court that since this is a dispute with respect to the boundaries of the property.
Sir?
That's at page 65, my lords. My lords will find at 69 is it begins, my lords. The directions are at page 70 onwards. The plaintiff in the present suit is at page, the respondent number 13 there, my lords, represented by an advocate.
Issue a writ of certiorari to modify the layout plan.
Please.
Insofar as involvement of the land of the petitioner.
In Kaneshwari number 61, while annexed so and so, to hold that the various deeds under so and so, true copies of the sale deed dot so and so are honest in the eyes of law. All these sale deeds are executed by the third respondent cooperative society, my lords. There was a dispute with respect to where their layout is and where my property is. Therefore, ADLR was directed by this honorable court to measure the property, and the report was filed. And that fact has been materially suppressed.
Where this order only says about that? Where is the report and all?
Plus, report is, my lords, at annexure G onwards, my lords. That is in Kannada, my lords. I'm sorry. The sketch is also, my lords, will find at page number 83.
No, this order only refers to conducting the survey.
Yes, my lords.
Nothing else.
Thereafter, the survey was conducted in the presence of the respondent number 13 in that writ petition, who is the plaintiff. His representative has come and signed the merger. And my property is demarcated and their property is not found in my property. Plus, ultimately, my lords, it's a dispute with respect to the boundaries. This is a material information which they should have disclosed in the plaint. The previous litigation is a necessary requirement to be disclosed as per the directions of this honorable court in Sujay Enterprises matter. My lords.
This is a bare injunction suit.
Bare injunction suit. My lords.
Come to the order.
Page 22, my lords. Fourth line, the ADLR report relied upon by the defendant. The ADLR report relied on by the defendant has not been proved in any civil proceedings, and therefore the said report is not conclusive to decide the possessory rights of the parties. Besides, when there is no admission of the ADLR report by the plaintiff in the plaint, it cannot be a ground to reject the plaint on the ground of suppression of fact or non-disclosure of cause of action.
No, how will the court come to know about this ADLR report and all?
They should have disclosed in the plaint. That's the requirement of law, my lords.
Correct.
Please.
Now, while considering an application under Order 7 to 11, court will not look into your written statement.
Understand, my lords. I understand. Therefore, my lords, when the may I draw my lord's attention to one judgment of division bench judgment of this honorable court, where this element of suppression of material facts has been a rampant issue, my lords. This honorable court gave a direction. Let's kindly see para 46, last page. 46, my lords. Para 46, last page. 4654. For the foregoing reasons, we strongly feel that in order to check multiplicity of proceedings pertaining to the same subject matter, to make justice delivery system faster and lesser expensive, and more importantly, to stop the menace of soliciting inconsistent or supplemental ex parte orders through different judicial forums by suppressing material facts, either by remaining silent or by making misleading statements in the pleadings, in order to escape the liability of making a false statement, in our considered opinion, the parties to the dispute should necessarily be required to disclose in their pleadings the details of all legal proceedings and litigations, either past or present, concerning any part of the subject matter of dispute, which may be properties movable or immovable, and or claims, rights, obligations arising out of contracts, customs, so on, so on. So, in case, according to the parties to the dispute, no legal proceedings or court litigation was or is pending, they must specifically state so in their pleadings. This is a bounden duty on them, they will impose, my lords, which they have not disclosed. In the entire plaint, my lords, there is no reference to the order.
Still we are at the same point.
My lords.
Now the court has looked at the averments made by the defendant, the documents filed by the defendant, to reject the plaint.
It's a case of
whatever it is.
It's a case of where this honorable court will not exercise jurisdiction in favor of a party who has suppressed the material facts.
No, that once that court has looked at the documents, the survey report, the order of passed in the writ petitions.
True, my lords.
Can the court look into if that is
under,
the case?
Under Order 7A, 11A may not be much, but under 11D, yes, my lords.
No, Order 7 Rule 11 entire that is a settled law. If you show
otherwise, my lords.
If you show one judgment, because these kind of things we can, provided the law says so.
One more judgment of Supreme Court in Kishore Mathre's case, my lords.
Check that.
2013 2 SCC.
Yes. Which paragraph?
Para 32, my lords, where the obligation for disclosing the material facts at page.
Arising out of Order 7 Rule 11.
It's not under Order 7 Rule 11.
So in that case, for that, we don't require a judgment.
My lords, ultimately, my lords, it's the stream of justice which should not be polluted, is what this honorable court
but
and
unfortunately, we are guided by such procedural laws.
Here, my lords, when there is suppression of material facts, the courts have said
that
we will not exercise the jurisdiction.
Open to you and you can demonstrate it before the court.
Kindly see, my lords, page 39, page 424 in that judgment, my lords.
Yes.
Para 38, 423 and 428, and I'll rush my case, my lords. Para 38.
Yes.
No litigant can play hide and seek with the courts or adopt pick and choose. True facts ought to be disclosed as the court knows, but not facts. One who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. Suppression or concealment of material fact is impermissible to a litigant and even as a technique of advocacy. In such cases, the court is duty bound to discharge rule nisi and such applicant is required to be dealt with for contempt of court. I rest my case, members.
Please come. Agreed with the orders passed on I number 3, invoice number 4547 of 2025, dated 22nd November 2025 by the so-and-so. The petition is before this court. The respondent herein has filed a suit for injunction in that the present application is filed under order 7 to 11D, seeking rejection of the plaint on the ground that the material facts are suppressed by the plaintiff while filing the suit. It is a case that the petitioner defendant has filed a WP before this court, that is WP number 8681 of 2024, dated and that came to be disposed of by order dated 10th January 2025, wherein the court has directed the respondent therein to conduct the survey as requested with the petitioner in the presence of the petitioner and the respondent. It is the case that as per the order of the court, the survey was conducted, and as per the survey, what is the survey? It says?
The survey says, my lords, this my property and their property are different.
The property of the petitioner and the property of the respondent are different. It is a case of the defendant that when these proceedings are very much, when he has filed a suit for injunction against the petitioner herein, all these aspects ought to have been brought to the notice of the court. As such, he has filed an application seeking rejection of the plaintiff for suppression of the material fact that came to be dismissed by order impugned. While dismissing the application, the court has, where is order?
That's page 22.
22. The court has dismissed, while dismissing the application, the court has observed that the events related in the plaint are commensurate with the relief sought in the plaint. Consequently, necessary cause of action is made out in the plaint. Insofar as the suit being barred by law, it is noted the defendant has vaguely pleaded the suit is barred under law without referring to any specific provision. The contention that the plaintiff has not produced a document to prove the actual position cannot be a ground to reject the plaint. And where is that decided? When there is no admission of the ADLR report by the plaintiff in the plaint, it cannot be a ground to reject the plaint on the ground of suppression of fact of non-disclosure of the cause of action, and accordingly dismiss the petition. Land counsel appearing for the petitioner submits that. The court, when the non-disclosure of a material fact is a ground to dismiss the petition, he has relied on two judgments. He relied on the judgment of the apex court in Kishore Samriti versus State of Uttar Pradesh and others reported in 2013, 2 SCC 398, and also a judgment of the division bench of this court in case of Mrs. Sujay Enterprises versus Airport Authority of India, reported in ILR 2001, Karnataka 4634. In this judgment, he relied on paragraph number
46.
46.
Last page.
Para number 46, extract. Relying on this, it is submitted that the court ought to have considered this aspect, and the petitioner who has come before the plaintiff who has come to the court with suppression of material facts is not entitled for any not entitled for a relief of injunction. Next para. In counsel appearing for the respondent submits that the trial court had rightly considered and passed order and no interference is called for with the well considered order passed by the court. Next para. Having heard the counsels on either side peruse the material on record. When an application is filed under order 7 to 11, the court, it is settled law that the court will look into the plaint and the document that are filed along with the plaint. According to the petitioner defendant, there are suppression of facts by the defendant that he wants to demonstrate by looking at the objection, the application that is filed, by looking at the written statement and the other documents pertaining to the writ petition and to the survey. Admittedly, all these documents are not part of the plaint. If they are not part of the plaint, question of looking at those documents in an application under Order 7 Rule 11 does not arise. Even the judgment that the petitioner are relying on or on the proposition of where there is a suppression of material facts, but that cannot be applied to the facts of the case where an application is filed under Order 7 Rule 11. In that view of the matter, this court finds no reasons to interfere with the order impure. Accordingly dismissed.
Your Lordship.
My lord, serial number 112, my lords. The repetition has become infructuous, my lords. Serial number 112.
Yes, it is submitted that the petition has become infructuous. Dismissed as infructuous.
Serial number
Yes.
9.
Your Lordship.
Number 45.
Your Lordship, serial number 139, Your Lordship. It was
Urgency.
Then for all these mentionings are only 230 mentions to be made if there is urgency. Other memos will be given to the court officer, and contrary to that, any mention is made, I will be raising. Yes. Yes.
In that for past 4 months, I was striving hard to get it reached before the court. Any date may be fixed by law on top of it.
But what to do? There are so many people like you.
I got taken the step.
We'll see. No. Yeah. For that memo, it's not it. If you give the memo, I'll look into it and out of the turn, if you want to take that matter, tell the court officer, give the memo to her, writing the urgency, I will look into it. Those kind of matters, please don't mention. Only 230. Anything?
Lordship.
24, I seek for an adjournment. 24, I seek for an adjournment, Lords. I do not have any urgency.
24?
Serial number 24, list 1.
List 1.
You have an interim order?
No, my Lords, I don't.
Yes, list this matter in the month of October.
Second, Milord.
Yes.
Milord, second list, Milord. Serial number 6. Date mean, short date. Second list.
Then I've already said, no, I'm not listening to any of the mentionings now.
Your Lordship, for 230, Your Lordship, serial number 139, Your Lordship. It was there for 230.
Lordship, serial
Because
number.
matter is not reaching, that is not a ground to take
No,
up
Your
the
Lordship.
matters at 2:30.
Your Lordship, our matter was, Your Lordship, it was.
It will come another 11 times, sir.
Your
That
Lordship.
can't be a ground for what is the urgency? What Galata? What is that? What is that petition? What is the urgency? Arising out of which order? Rejection of a plaint, that is an urgency and law and order issue.
Your Lordship, serial number 139, it is an execution petition. It was there for 230, Your Lordship. It was a matter of 2005, Your Lordship. They have suppressed the material fact that Supreme Court has dismissed the petition also, and it has come for attachment. Now at the stage of attachment, they have having no other means, they have filed this petition challenging IF-14, which is authorization, only an authorization of a company who represents a company in the trial court, executing court. The file and taken no precipitated action. They are treating it as a stay and continuing the matter with the trial court, Your Lordship.
When was the stay granted?
Stay is not granted, Your Lordship. They are submitted and the stay has been granted. We have said only undertaking that we will not take any coercive action until the next date of order. That was previously, Your Lordship, 230 kindly.
And any of the matters, if you don't inform the other side, I'll not take up.
Please, no, Lordship.
Serial number 2.
Serial number
2
14.
Serial number 2 in list number 2, my lord.
Yes.
My Lord.
Serial number 2 in
Yes.
serial number 2 in list number 2, my lord.
Yes.
That it is listed for taking out steps for R2. R2 is a co-defendant, so that I am filing an application for the memo for dispensation, that the notice of issuance to R2 may be kindly dispensed.
My lord, in execution.
Matter may be
Serial number 107.
serial number 2. Matter may be listed for admission tomorrow, my lord. That
Your
the suit
Your
is
Lordship,
being
serial number 14.
My-
Your Lordship, serial number 14.
My lord.
list number 2. Madam,
Yes, sir.
list number 2, serial number 2.
ಏನಿದು?
Dispensation.
33, not maintained petition.
ಏನ್ ಹೇಳಿದ್ರು ಮೇಡಮ್?
Madam, 107
Number.
Co-defendant is.
Sir, ಕೊಡಿ sir number.
ನಾವ್ ಹೆಂಗೆ fill ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
107.
ಅವ್ರು ತಗೊಳ್ಳಿ ಏನ್ರು
107.
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ನಾನು ಪುಟಪ್ ಮಾಡ್ತೀನಿ.
ಮೇಡಮ್ 107 ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹೇಳಿದ್ ನಾನು.
ಮಾತಾಡ್ತಲೇ ಇದ್ರೆ ನಾವು ನಿಮ್ಮ ಅಕೌಂಟ್ ಸುಮ್ಮನೆ ಕೆಂಪಿಲ್ಲ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಆಮೇಲೆ.
107
ಫೈಲ್ ಮಾಡಿ ನಾನು ಪುಟಪ್ ಮಾಡ್ತೀನಿ.
ಸೊ ಪೋಸ್ಟ್ ಲಾಂಚ್
ನಮ್ಗೆ ಏನು ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್ ಮಾಡಿದ್ದೀರಲ್ವಾ ಹೇಳಿ.
107 ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ನಮ್ಗೆ ಅದೆಲ್ಲ ನಮ್ಗೇನು ಡೈರೆಕ್ಷನ್ಸ್ ಇಲ್ಲ. ಈಗೇನ್ ಅಲ್ಲಿ ನಮ್ಗೆ 230 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ ಮಾತ್ರ ನಾನು ನೋಟ್ ಮಾಡ್ತೀನಿ.
ಇದು ಈ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡಲ್ವಾ? ಇದು ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್
ಎಲ್ಲಾನು ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ನಿಮಗೆ ಆಪ್ಷನ್ ಇದೆ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ. ಲೆಟ್ ದ ಕೇಸ್ ಆಫ್ ದ ಕಮ್ ಅಂಡ್ ಲೆಟ್ ದ ಇನ್ ದ ಫೈಲ್. ನೀವು ಇಲ್ಲಿ ಹಾಕ್ತೀರಾ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಅದು ಎಲ್ಲೋ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ದೇ ವಾಟ್ ಇಸ್ ದ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಫಾರ್ ದಿ ಫೈಲ್ ಇನ್ ಕೋರ್ಟ್
ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
that is after 230.
No, they'll take 230 route matter set 430. They'll continue.
You shouldn't ask that because you are more well versed in the law than me.
ಈ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಏನು ಕೊಡಲ್ಲ ಇದು ನಮಗೆ ಕೋರ್ಟ್ ಅಂತೂ ಬಹಳ ಕಷ್ಟ. ನಾನು ಯಾರಿಗೂ
ಅಲ್ಲ ಸರ್ ಅದ್ರ ಬಗ್ಗೆ ನೀವು ಇದನ್ನ ನಾನು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀನಿ ವಿತ್ ಲಿಬರ್ಟಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಇದು ಅದನ್ನ 2:30 ಬಂದಾಗ ಕೊಡಿ. 2:30 ಬಂದ ತಕ್ಷಣ ಲಿಬರ್ಟಿ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್ ಐ ವಿಲ್ ಬಿ ವಿತ್ಡ್ರಾಯಿಂಗ್ ದಟ್ ಫೈಲ್ ಟು
ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಸರ್ ಅದೆಲ್ಲ ಡೈರೆಕ್ಷನ್ಸ್ ನನಗೆ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ 107
ಅದೆಲ್ಲ ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದೆಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ನಾವು ಅದನ್ನ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಸ್ ಪರ್ ಬೋರ್ಡ್ ಅಂತ ಇದೆ ನಮ್ಮ ಡೈರೆಕ್ಷನ್. ಅದ್ ಸಂಜೆಗೆ ನನ್ಗೆ ಏನ್ ಡೈರೆಕ್ಷನ್ ಬರುತ್ತೆ ಅಂತ ನಾನು ಐ ಕಾಂಟ್ ಟೆಲ್ ನೌ ಇಟ್ಸ್ ಸರ್.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 107 ಈ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 107 ಕೊಡ್ತೀರಾ ಮೇಡಮ್ ನಾನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್
ಏನ್ ಮೆಮೊ
Court officer? Court officer? Court officer? ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?